Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Welcome back. Welcome back. 1 second. I'm hearing Judge Krupp in my ear, and I'm like, ugh. I wanted to pull that up for you guys. How's everyone? Hello, fam. Today's Wednesday, August 6th, 2025, and it's Melanie After Dark. So, let me take this off. This was the banner from the last show that I did about poor Martha Nolan, who was found dead in Montauk. Okay, on a boat named Ripple. A Grateful Dead boat with a Steely on the back. Also, I'm a Buffs fan. Go Buffs! Proud alum of the University of Colorado Boulder. Cleveland Browns have just announced that Shedeur Sanders will start as quarterback against the Panthers on Friday. Is it already football season? Is it already football season? Is that preseason? What are we doing here? Why? Summer's not over until I say it's over, okay? It's not. It's only the beginning of August, and I know that it's coming up soon, but we can still have some summer, can't we? I say we can. It's preseason. All right, it's preseason, but good for Shedeur. Good for Shedeur Sanders. Getting in there, starting. I like it. It is moving too fast. Your life is, the older you get, the faster time goes. Does anybody notice that? The older you get, the faster time goes. I don't know. It's weird. Well, yesterday we were expecting to have a barbecue in Norfolk County. Everything was going to be seasoned with rosemary. First thing on the barbie was going to be Adam Lally. Second thing on the barbie was going to be Michael Proctor with his newly shaved head and his mirrored sunglasses. And didn't happen. Didn't happen because Judge Krupp said it wasn't going to happen. And then he put it over till I think the 12th. But he also said, as I recall, that that's going to be a non-evidentiary hearing. So Proctor and Lally are not coming back on the 12th. I think there's a little misunderstanding about that, because he did say it's going to be a non-evidentiary hearing. You're just going to report back to me and tell me if you made the charts to my satisfaction, right? So they're not coming back next week. But what I want to do with you, because of course they dumped a whole lot more discovery on Rosemary Scapiccio, defense attorney for Myles King in Norfolk County, Massachusetts, where your constitutional rights go to die, and the tentacles of corruption and or incompetence run so deep, and they're twisted. And it's been like that for decades. And it took Karen Reed to come in and start to expose it. And now that Alan Jackson has joined the civil team for her wrongful death case, this means war. This means war. They're not done. He's not done. He said it yesterday. He's not done. And let's do this first. Let's do this first. First, I want to go back to the hearing from July 21st, because that's the hearing where Lally took the stand, remember? And he was up there, he was on the Barbie for about an hour. All right, so let's see, he got on the stand at about like 16 minutes, and he went off the stand at about an hour and 16 minutes. And I want to go back and listen to what the judge said after Lally gets off the stand, because that's when he started talking about, the charts that he wanted Rosemary Scapiccio, my new spirit animal, to prepare for him for the next hearing, which was yesterday. Now, it is important to note the defendant, Myles King, had been in the Norfolk County Jail from the day of his arrest in 2021 until about 1 month ago, when he was finally released on a $10,000, I think it was $10,000 cash bail. They kept him in jail for nearly 4 years without a trial, without turning over evidence. And really, when Lally got up on the stand, he really made it very clear that he just could not care less. He couldn't care less. He doesn't care. He's lazy. He's been working there for 20 years. And so what? So what? I never followed up with Proctor to get those search warrants. So what? I guess I forgot. I don't know. And she was just starting to Rosemary Scapiccio was just starting to get into the meat of it when Krupp said, "Oh, you know what? We're going to stop for today." Was it because they were getting a little too close to the custom, habit, and practice of what's been going on in that DA's office for decades? Because in my opinion, Judge Krupp did a complete 180 between July 21st and yesterday. Yeah, was he told to do the right thing? Did Michael Cox call him to the office and say, "Hey, Pete, wink, nod, say no more, and do the right thing. Do the right thing." Judge Corrupt, people are calling him KORUPPT. I saw that. Are they getting a little too close to the truth? Why? Why is the judge stopping the questioning? Why is he putting the onus on the defense to now do all this work for him? He did a 180. We started to like Judge Krupp. We started to like him during that first hearing. We did. Because he was allowing it to happen. He was allowing her to ask the questions that everyone wanted the answers to. He was allowing Lally, he was forcing Lally to say the quiet parts out loud about how incompetent he is and about how they have no system. And about how he didn't follow up because he really didn't even have a reason for why he didn't follow up. Let's go back and watch the last 10 minutes of that hearing where Judge Krupp tells Rosemary Scapiccio what he wants her to do for the next hearing. And shout out to the trial channel for doing the Lord's work. And clipping everything in a way that we can go back and watch it later. So shout out to the trial channel. Make sure you give them a sub and a like, because they do this for many, many, many trials. And they break the testimony down of each witness into separate videos and cut out all the sidebars and the chit chat and all of the dead air. And here's the last 10 minutes of that hearing after Lally got off the stand. Let's listen together.
Docket number 8 in the case. All right.
Let's see how Lally ends.
You see the file and ensure that I have. Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that A.D. Hickman.
This was so fun. Let's take it back a couple more minutes. Let's just listen to him for 10 minutes, and then we'll get into what the judge says. We'll listen to the end of his testimony.
Search warrants after indictment. Obligation on the defense counsel post. Did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were,
Question. Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
Well, he's a lawyer. He's a lawyer. What do you mean it's a legal conclusion? He's the freaking lawyer. He is a prosecutor. He is an ADA. He should know what his obligations are. But as soon as she starts getting into asking him what he knows and what he knows he's supposed to do, and if he knows what he's supposed to be doing, listen to that again. The judge is going to cut it short. Is he protecting Lally?
they were,
Question. Do you know whether or not there is an obligation on behalf of the district attorney's office?
Whether or not there's an obligation on behalf of the district attorney's office. That's like district attorney school 101. You need to know what your obligations are. You need to know what you're supposed to turn over. You need to know what you're supposed to be telling the defense because you have those obligations. Why is that like a legal conclusion that Lally can't answer? I'll never know. But of course, this attorney gets to state the grounds for his objection, like we've never seen in Massachusetts.
Specifically, to notify defense counsel if you're seeking search warrants after indictment.
Objection. If this is a legal, yeah.
Sustained.
Thank you.
That's Lally's attorney.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
yes.
Okay.
Right. This is when he's certifying to the court, in open court, when he still had the case, that discovery was complete, that he'd already turned everything over. But the thing is that he just didn't.
And then we come back, we suggest March and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date. So there may be a couple of other additional items of discovery that I need to get and turn over.
Okay. Sorry. That was the prosecutor. That was not his defense attorney because his defense attorney was there too. So despite the look on my face, you're still talking. If you know his name, I mean, his voice, I'm going to take your word for it because you may be right. I may be crazy, but it just may be a lunatic you're looking for.
But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
I don't.
Finish, Your Honor.
Yes.
She's got the transcripts. She's got the
These
transcripts.
transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask,
Right.
Judge.
Great.
Great. Thanks, Your Honor, for telling us that everything is in a transcript and that we can read it for ourselves and he can read it for himself. But in order for her to get the answer to her question, he needs to read his testimony if he doesn't remember. And this is she paid to get these transcripts of these pretrial hearings in which Lally said all the discovery was exchanged and it was all complete. And how are we to know, or how is the judge to know, because he is the finder of fact here for this purpose? How is he going to know if these are egregious discovery violations unless he hears from Mr. Lally and what he knew and what he had and what he didn't have and why he lied to the court and said all discovery was complete? I'm still mad about this and I'm not going to shut up about it. So let's keep going.
So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Good. There's the
Do you have any
transcript.
notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay.
You might have notes.
Now,
They might be in the file.
other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Pretrial conference
Okay.
record.
But you understand, normally we
Report.
file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay.
This is the July 21st conference. We're just going back and
And
watching
you don't
the end of
remember
it.
signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
He just doesn't care.
In-person meetings, no.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes,
And did you follow up with the Milton police the same way that you say you followed up with the state police?
yes,
And did you follow up specifically with Lieutenant Collins?
yes.
And so what in your mind was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
False memories.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes,
Or there have been emails back and forth between you and Milton about what transpired?
yes,
Okay, did you have any trouble getting information from the Milton Police Department?
no,
When you asked for things, did they return your email and give you what you were looking for?
yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Oh, he'd never seen it before.
Okay.
2025 comes. There's a new police report regarding a different guy, Mr. Turner. I don't know. Is he another suspect? He'd never seen it before. Didn't get turned over. He didn't see it until 2025. Again, this shooting was in 2021, I think July.
And do you know why that wasn't turned over by the Milton Police Department?
No,
Did you go down to the Milton Police Department and look through their file?
no,
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
no.
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point?
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
Oh. Mhm.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
It's an ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I've requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file
That's the judge.
while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
No. See, now the judge knows
Can you
there's
tell
a
us of their
problem.
policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months before trial.
And is that the
Years.
first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Okay.
And now he
And the
changed
state
his,
police the same way? Did you sit down with them at some?
because now he's saying he changed his procedure. Now he's going to do it much earlier, but for 20 years, he did it that way. where he didn't even sit down with them until right before trial, which could be years from the crime or alleged crime.
Some point and look through their file, or you never looked through their file?
No, as his honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or did it, at any point, did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go in this case,
He should be humiliated, but is he? I don't know. Thanks, I'm sorry.
you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
We have a sigh emoji for that.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay, so when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So he doesn't meet with them until it's closer to
understand.
trial, but by then it's too late because he's already certified to the court that all of the discovery has been exchanged. Do you see how that's a problem?
Is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA Lally these documents on this date?
As far as their list,
Yes.
I have no idea what they have.
Okay. So you don't know as you sit here today if they have an index of all the things they say they gave to you.
One hand doesn't know what the other hand is doing. They never thought they were going to get caught. They never thought anybody was going to call them out on this BS that they have no procedures and protocols and chain of custody. And this is just the way they do it. This is not the way it's supposed to be done. And this is not just what happened in the Karen Reed case. And the more cases that we look at in this county, the more you're going to see that. I have a feeling.
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here? I've been requesting something since, December of 2021.
It's called a tickler system. Every law firm has one. We've had them since, I became a lawyer in the 90s. It's like a system where you remind yourself, it sends you calendar reminders on things. Tickler is like a system, is a reminder system. I was a lawyer before he was a lawyer, and we had him back then. So the fact that they have no tickler system shocks me. Or he just doesn't know how to use it, or he just doesn't use it, or he just doesn't care. He just doesn't care. Hello, Southern California. Love Southern California. Redacted 83.
I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date.
This is the first time. I remember at the beginning of this hearing, this is July 21st hearing. He said, I have until 11:30. We can go until 11:30. And then all of a sudden, Lally starts drowning. Lally's drowning. He needs a life preserver. And he's like, oh, you know what? It's, we have only until 11:10 now. Okay. So, because I wanted to play this because I wanted to see where the judge cut it off. If it was because Lally was drowning and about to expose the whole entire county, the whole DA's office for their lack of procedures, protocols, custom, practice, habit, tickler system. And that's exactly where he cuts him off. He doesn't want him to have to say any more, maybe, in my opinion. Doesn't the MSP and the Norfolk County DA's office, aren't their offices in the same building? Are they in the same building, like down the hall? Or is the MSP or the MSP troopers assigned to the Norfolk County DA's office in another building? Because really, if he couldn't even walk down the hall, I mean, if he had to get in his car, I guess, and go somewhere to travel there to look at it, maybe I could cut him a break. Not really. But if they're in the same building and they're literally down the hall or on another floor, you couldn't get in the elevator and go, really? Thank you, Scott McGinnis. Same office. Ashley said down the hall, same, but they're in the same building. They're in the same mother effing building. And this guy can't go look at their file because it's not important because they've gotten away with it for so long. Why should they start doing anything by the book? This is gross. And now I want to hear what the judge says about what they're supposed to prepare for next time, which is yesterday. So let's listen to the words that he chooses and the words that he doesn't say, because both of those things are important. As I always tell you when we're watching, especially press conferences, I'm going to speed it up to 1.5. Lawyers choose words very carefully. And so every word that they choose is chosen for a specific purpose. And also what they don't say is oftentimes just as important as what they do say. So let's listen to what the judge has to say after he lets Lally get off the Barbie.
We can come back and continue the hearing.
Clear.
Okay, Attorney Lally.
He says, we can come back and continue the hearing, okay? This is an evidentiary hearing during which testimony is taken. He just said, so we can come back and continue the hearing, okay? That doesn't mean we're going to come back and then I'm going to tell you I'm not going to take testimony. That is, we're going to come back and continue the hearing. So just listen.
Time to break, and we need to talk about another date when we can come back and continue the hearing.
Clear.
Okay, Attorney Lally, you can step down. Thank you.
Thank you so much. I saw some gifts flying by, so I want to thank you before it gets too far away from me. Boston Girl 79, aka Charissa, gifted 5 memberships, and the Goodmans are here, and they gifted a membership too. Oh, so kind and generous, all of you. And also, then I think Boston Girl came back and gave another 5 memberships. So if you were gifted a membership by either the Goodmans or Boston Girl 79, aka Charissa, be sure and thank them, because you too now can use all the special emojis that we have, most of which we made for this Karen Read trial season 1, including, remember the old puffy jacket, the solo cup? We've got it all. Wait for us. Remember Wait for Us? Oh, that'll go down in history. The olden days. The olden days. Thank you very much, Boston Girl, Charissa. I'll get to these super chats in a minute. Let me just let the judge finish talking and telling Rosemary what he wants for next time.
For the record, I think the defendant's general motion for relevant discovery is...
Hold on, watch Lally get off the stand. He almost bumps into the wall. Hold on. I'm going to put this on slow speed. Put it on 75 speed. Hold on. Bumps into the wall.
Attorney Lally, you can step down. Thank you.
Watch this. Oh.
For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21, CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Mr. Piccio.
It was on behalf of Ms. Gardner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates.
That'll leave a mark.
I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
I would like to have the benefit of your chart. I would like to have it. He doesn't say, you better have it or we're not going to hear any testimony, right? All right, let's keep going.
So, might I ask also that the court order, if they're materially prejudicial to the defendant, as we explore discovery.
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced? If
Right.
These materials.
Right. It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed. Okay. And
Might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches. Okay. We can deal with April and then we can deal with May.
Okay.
And
In tranches. He said it would be helpful to me. He doesn't say you are required to have this or we're not going to hear any testimony. It would be helpful to me. We can do it in tranches. She says they just dumped a whole bunch of stuff on me about a week ago. And it's going to be hard because remember, they dumped like between April and May of 2025, something like 380 something pieces of evidence that were multiple pages. And that is why they eventually had let Myles King out on bail. He had been held without bail pursuant to the Massachusetts rules on first-degree murder. But it was taking so long.
if we have to deal with it in parts, we can deal with it in parts.
So we can deal with it in parts.
I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel files a motion? Up until that point, I'm not going to.
Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss.
Okay.
That motion was filed on, I think, May 28th, 2025.
Do you now view as prejudicial? That is to say, and frankly, how you were prejudiced. Okay, this is a witness who's deceased, or we have no way of following up on this, or whatever it is. Okay.
That's only part of the other. I don't want to not meet before that.
I would like you to do a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we can continue this hearing.
Sure.
Continue the hearing.
How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in? I think.
Sure.
Another ADA's draft.
Sure.
Parties. And I know we have counsel here for another party, so.
Mm-hmm.
If somebody has the transcripts of all the various hearings.
I do, Judge. I'm happy to share them with everybody.
Yeah, share them with everybody and let's
Talked to me literally late last night.
all right. But my point is, in the next hearing, stand up and say, Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1. Okay. And Exhibit 2 is our reconciliation between the documents. And this is the way in which they're different or new. Okay. And Exhibit 3 is whatever else you want. Here's our discovery report. And here's my discovery motion. And here's the motion. You don't need a witness for that. These are all part of the record. And there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But so I think this can be done in a much more streamlined way. And hopefully we can do it that way.
You don't want the world to see, and the world is
how much
watching.
more,
He's understanding that now.
What other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate
Trooper Proctor, who didn't join us today. Remember, he was a no-show. He had a vacation, apparently, so subpoenas don't apply to him.
ADA
Hickman.
Hickman. Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Kelly.
Tully.
All right. How many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins and Officer Benda, regarding the Milton issues. And there's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman, being the predecessor counsel and now counsel of record on the case.
Jim's forehead.
She can answer any questions the court has that are remaining from right where she stands.
All right.
And opposing the production of.
All right. So we have 4, maybe 5 witnesses left. So we need a day when we can do this in an efficient way.
He's clearly saying that the next day that we're coming back is the day that we're going to have more testimony. And she did give him the charts that he asked for. And she said, here's a chart of everything that we agree was turned over late. And here's a chart of everything that we agree wasn't turned over late. And then here's a chart of the things that are in dispute. Because do you think that the DA's office is ever going to agree that they didn't do anything wrong? This is it's ridiculous. He's the finder of fact. She listed something like 300 and I lost 330 something pieces of discovery in the motion. There were pages and pages and pages. Remember how I was scrolling and scrolling and scrolling through pages of all the discovery that was turned over late?
Jim, how does our calendar look?
7/29, which is a Tuesday,
Yep.
is particularly good.
Particularly good.
Well,
There was a reason for that. I'm trying to remember what that reason was.
Tuesday.
We have a noon lobby conference.
There's a lobby
I have
conference.
a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
Yes, they got more. I'm going to show you what else
We have anything
I
on
just
that morning?
dumped on
We do
them.
not.
No?
Should we potentially push this to the first week of August?
The 30th is a problem for you?
Hi, Kelly Reed.
6th is out. 5th is a possibility.
All right, so then now they're just talking about scheduling. Kelly Reed is here. Hi, Kelly. Says Lally never turns over discovery on time, and he's never disciplined for it. People will always do what they can get away with, right? You know what they say, what you allow continues. So they're talking about dates to come back.
That's locked up.
He's-
Let's just
Is-
pull up the list for this. I know I am not away that day.
So he's just talking about dates now, but I mean, it's kind of like,
All right.
Does it work for
Witness issues, August 5th? That's okay? All right.
So Judge, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate a new date to him so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor.
I don't want him to
he
have
can
to
be
go
available
back
August
to
5th.
his home. Do you hear? Because I want to play that a little louder for people in the back. She says, Judge, could I know that he's going to show up on the next date? Because I don't want to have to go back to his home. Like, she's the one who went and actually served him with the subpoena. What do you think happened when she got there? Listen to this again.
Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate a new date to him so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor. He can be available August 5th.
Okay, good. So,
Oops. What just happened?
9 o'clock?
Sure.
I would like to get,
What just happened? Hold on. What did I just do? Go back.
the agreed to exhibits, including, the transcripts of any prior hearings, any prior filings that you want to.
Let's talk a little bit about
Oh,
what we're going to court
no.
in. It is
Now you know my
a
history.
homicide prosecution.
I did watch Emily Baker today. Hang on a second.
To you.
How about the 30th in the morning?
And so that was it. They just talked about dates and they were like, make
looks
sure
like we
Proctor
could do
shows up
August
because
5th.
I don't want to have to go to his house.
We don't have to reserve him. I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor. He can be available August 5th.
Okay, good. So, 9 o'clock?
Sure.
I would like to get, the agreed to exhibits, including, the transcripts of any prior hearings, any prior filings that you want to draw to my
The agreed
attention,
exhibit.
the reconciliation of exhibits, et cetera, in advance. So, I am away the 31st and 1st. So if I have them here by first thing on the morning of the 4th, I'll read them all before the 5th, okay? So, I'm not trying to create artificial deadlines for you, but I think everything will go faster if I've had a chance to take a look at the agreed to exhibits, okay?
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
9 a.m.
So it was like
I'll
he
take a,
wanted
we'll
the
take a
agreed upon
15-minute break
exhibits.
and reconvene 11:30 on,
She brought that. Okay. And then they show up for the hearing yesterday. You know what happened because that was just yesterday. I didn't hear him say anything like, if I don't get that chart of all the things that you say are, you know, prejudicial and why they're prejudicial that you didn't get them on time. We're not going to take testimony. Did anybody hear that? Because I didn't hear that. But in case you weren't here yesterday, Lally made a diary entry for you by Emily C. Emily C is here. And that reminded me that I wanted to show you Emily's diary entry from yesterday for Adam Lally. And if you don't follow Emily C on Twitter, what are you doing? What are you doing if you don't? It is on Lally stationery dated 8/5/25. And at the top of the loose leaf paper, it says, start fresh, dream big. Dear diary, my lawyer got me out of having to testify today, so my anxiety pack of Marlboros became my celebratory pack. There's just one problem. Mr. Betterow has been telling all the kids in Twitter law school that I should lose my job immediately. And when those kids get fixated on something, they do not give it up. Imagine what I could do if I had a quarter of their motivation. Mom picked up a few job applications for me to get started. Gonna go fill those out now. It's really a bummer because I love working at the Norfolk District Attorney's Office, and I'm not really qualified to work anywhere else. XOXO, Lally. It's very funny. And then she attached to it a Subway sandwich store application, which is very funny. So I don't play on Twitter, as you know. You can still look at Twitter if you don't engage on Twitter, just so you know. But go follow Emily C on Twitter because she's hilarious. And she did a diary entry for Lally and some for Brennan for every single day of the trial. And it was delightful. It was delicious. It was all of the wonderful things. And so let's go to the chat for a minute before we look at the discovery dump that happened today. No love of the traveling trooper says, look at me, I'm traveling. Thanks for your super chat and for coming to me with me to both shows today. Ashley says, Judge Krupp represented Bulger for 2 hearings before Hank was hired. Well, you know, small county and all, Ash. Thanks. I also saw something that he's been on a couple of panels with Judge Cannoni teaching. He's a teacher. He and Judge Cannoni might know each other. They work in the same building, so not unusual. Norman says, thanks for fixing my super chat problem. I'm all set. Thank you, Norman. It has happened to a lot of people. One day I had Nightbot on, and Nightbot went rogue and it blocked a bunch of people. And also YouTube has been blocking a bunch of people. So if you find out that you're blocked and you have no idea why, because I don't block people, typically the mods do that. And unless you're really egregious, you don't get blocked. Just shoot me an email, but I need the link to your channel, not just your username on YouTube, so we can fix it. And that's what we did for Norman. Thanks, Norman. Ms. Holmes, why was Rosemary so meekish with Krupp? You mean yesterday? I didn't find her to be so meekish, Ms. Holmes. But I will say that you need to know, as an attorney, you need to know when to pick your fights. You need to know when to pick your fights. You need to know how to read the judge. And I think she knew yesterday it wasn't worth fighting about because he was not going to change his mind. In my opinion, I didn't find her to be meekish. I just found her to be not combative, let's say. Thank you, Ms. Holmes. Shannon Loves Connecticut says, should we anticipate a lot of previous convictions in Norfolk County will be examined for law enforcement and DA incompetence? Yes. I say yes. Yes. I say that every prisoner, everyone who's already been convicted, because remember, there's a lot of cases that are currently pending in which Proctor was the lead investigator. And we know who they are because we've seen them in the hearings about the destruction of Proctor's text messages that was supposed to happen. And there's only about, 5 or 6 defendants involved. But think about all of the people that have already been convicted. Think about all of the people that have been convicted. And Adam Lally was the prosecutor. There's 20 years worth of defendants, assuming that he got guilty verdicts. 20 years worth. And how long has Proctor been there? I don't know, 10? 10 years? How many years has Proctor been there? 10, 12? So, that's a lot of years and a lot of cases. And I bet you they're banging on the jailhouse doors, calling their lawyers like, yeah, Lally prosecuted me too. What didn't he turn over? Great question. Thanks, Shannon. Gigi is engraving the silver bracelets right now. Thanks for your 10. Says, Lally has such a smackable bald head. I volunteer to try it out to make sure I'm correct. I wonder if Lally has to have Proctor remind him to use toilet paper. I do not volunteer to confirm that. Thank you, Gigi. You have a very funny sense of humor. Heidi says, he's also the judge on the defense attorney hearing for Proctor's texts. Yes, might be the basis for the change in perspective from the bench. Feels like a flip-flop from the first hearing last week. Yeah, last week he was all gung-ho for Proctor and Lally to testify, and he set a new date, and the date was yesterday. And then he got a real snippy about the charts that Rosemary gave him, and she did give him the charts. He just couldn't understand them. Was that like just a reason to keep them off the stand? I don't know. But in my opinion, I think so. Because whether or not these were egregious violations is a question to be determined by the judge. He's the finder of fact. That's not something that Rosemary Scapicchio and the Norfolk DA's office are going to agree on. Oh yeah, you agree this was egregious? Yeah, it was egregious. Okay. We stipulate that these were egregious. And so, they're just going to dismiss the case against Myles King. Never going to happen. But without taking their testimony, how can the egregiousness of it, if any, be determined? It can't. There has to be prejudice, yes. But I would submit to you that holding on to basic search warrants that they've had in their possession since 2021 relating to the original searches of the Myles King case, and you don't have them 4 years later, that's prejudice. Yeah, why are they putting the burden on the defense? You're right. I mean, it's not, it's not enough that he was been in jail waiting for all this stuff for, almost 4 years. That doesn't really matter. But we know that one of the witnesses that they never turned over is now dead. That's prejudicial, don't you think? And yeah, dismissing the case altogether would be a severe remedy, and it's rarely, if ever, granted. But there are other sanctions that can happen for the DA's office, because until the DA's office gets spanked, they have no reason to change. They're just going to keep doing what they're doing. Why should they change? They get a slap on the wrist. And that's what Rosemary said in her motion papers in the motion to dismiss that we read the other day. They just keep getting a smack on the wrist. And so they keep doing it, and they keep doing it, and they keep doing it. And if it's not prejudicial enough to have the case dismissed, well, then certainly some of the evidence should be suppressed. And perhaps, there could be monetary sanctions. There could be a lot of different ways that they could be punished, but they can't keep getting away with it. Listen, I'm in New York. I don't have to practice there. I don't live there. I don't pay taxes there. You do. And you should be outraged. Thank you, Heidi, for your 20, for starting that conversation. And yeah, it's a total flop, in my opinion. Hope says corrupt Commonwealth needs to be rehomed. But will they? Because if the judges keep backing up everything that the DA's office is doing, they've all been playing together for many years, right? All the Norfolk County judges, all the Norfolk County DAs, all the troopers assigned to the Norfolk County DA's office. It's incestuous. They've been working together for years. You scratch my back, I'll scratch yours. Maybe a little quid pro quo. When you're good to mama, mama's good to you. That was so funny the other day when I said, you guys know, I was explaining quid pro quo, and then somebody put in the chat, knowing that my favorite musical is Chicago, because I had just been to see it again on Broadway. When you're good to mama, mama's good to you. And that's quid pro quo. Thank you, Hope. Boston Girl says, thanks, Melanie, Maz, and Cupcakes. Appreciate you all. I appreciate you too, Boston Girl 79, aka Charissa. Such a generous benefactor of the channel. GD's here again and says, don't drink the water in Massachusetts. There's Dave Matthews song in there too. Seems to be filtered through a dingbat filtration system. I mean, don't drink the water. Biatch 414 says, this is so infuriating. No one does anything. Nope, they don't. And even when they do, they just keep letting them get away with it, right? It's not a one-off. It's not a one-off. The Karen Reed case was not a one-off. This is the way they've been doing it for decades. They just never got caught. Boston Girl says in Bev's voice, that's how it's done in Massachusetts. Insert eye roll. Mr. Jackson. Look at V. Kaser. Been with me for 15 months. Says, yay, us. Arlene says, so glad you're back tonight. Love you. Oh, thanks, Arlene. You've been with me for 17 months. Space Dude is here for 8 months, and I like the tie-dye. Love the tie-dye. Kelly Reed's been here for 3 months. She says, I love Melanie, and I'm so grateful she found us. I'm so grateful that you continue to care and that you all continue to listen and you all continue to be interested in this, because this is outrageous. This is not the way it's supposed to happen. And we are outraged. Maya wanted to know if King's release was televised or streamed. Not that I'm aware of. Not that I'm aware of. I believe there was a hearing, but I don't know if it was televised. They don't really televise these things until somebody in the media makes a motion to go in there with a camera. So there needs to be enough public interest. And at the time that he was released, it was in June. That was like when the Karen Reed trial was in full force. So I guess nobody else was paying attention to that case. And I don't think it is. But Trial Channel, if you know, then you can find the Myles King hearing on bail where they did release him, and you can find video of it. Let me know. Francis Capello said, do you think you can get an interview with Rosemary? I would love to. I would love to. I don't know if she's going to be willing to talk about this case right now because it's pending and you've seen how these judges are. But I would love to. I'll reach out to her. If anybody has a bat phone to Rosemary Scapiccio, give her a call. And then I noticed also when they were doing roll call, when all the attorneys were stating their appearances for the record yesterday, there was somebody I think called named Nicole Scapiccio who was on the defense team. I don't know if it's her daughter. That's pretty cool. Redacted 83 says, been lurking since Free Karen Read season 1. You're a gem. Oh, no, you are. No, you are. Thanks for your 20. Kamick became a new member. Welcome. Lally's list of lies. Nothing changes if nothing changes. Thanks for hanging out for 17 months. And you will notice if you're new here that we have so many great usernames in the chat. You guys change them for every trial. And that's a great one. Lally's list of lies. Because you're the snark tank for a reason. And I love you with all of my heart. Peekaboo baby shark. That's another one. Baby shark hairdo. Because Lally, if you notice, has the little baby shark hairdo. Remember when your babies were little? Some of you might still have toddlers. And you put them in the bathtub with the bubble bath. And then you do the little baby shark fin hairdo. That's what we used to call him during the trial, baby shark. Because it's a choice. I'm not making fun of his hair. It's a choice. It's a choice. It's his own fashion choice. He chooses to use whatever product he uses, like dippity-doo, to make that shark fin. He has the man passed out in the snow. Thank you, Peekaboo baby shark, for being with me for 3 months. Heidi, thanks for your 50. Wow, that's really sweet of you. Bitch slapping our Rosemary is not acceptable, as happened yesterday. Her professionalism was honorable. Yes, it's hard. So many of you ask me all the time, like, how do you do it? How do you keep it together when you're being publicly ridiculed by a judge? It's not easy. It's not easy. Ask Tom Kokonowski. Thank you, Heidi, for your 50. You're amazing. Ask Tom Kokonowski. It's not easy. Jeepers, it's already his bedtime. And we're keeping him up because, he gets up at like 3 a.m. or something crazy like that. It's not easy to keep your cool like that. So you have to give credit where credit is due. We saw Alan Jackson lose it a couple of times and get yelled at. Right? And he didn't care. I don't care how it's done in Massachusetts, Your Honor. That's not the way it's supposed to be done. And the jury should be able to see the witness's face. I don't care if you've done it that way for 100 years, Your Honor. He did say in his interview on the radio the other day that we listened to that I think the guy said, so, what do you think about Judge Cannoni? Are you hoping that you never have a case in front of her again? And he said something like, yeah. He said, like, if I never see her again, ever, it'll be too soon. Like something such as like that. I'm summarizing, but there's no love lost there. Clearly. Julie O says, you got to watch Rosemary on trial 4. Same type of Krupp stuff. And even worse, she's a baddie. I started watching it last night, but I fell asleep. It's a lot of episodes too, right? I don't know if I can commit to it for that long, but I'll try. I will try. Thank you, Julio. But for those of you who haven't seen it, Trial 4 is on Netflix. It involves the case of Sean Ellis, who was tried 4 times in Massachusetts and spent something like 23 years in jail. And Rosemary Scapiccio was his attorney, right? It's a whole bunch of episodes. It's on Netflix, I think. Thank you. Edwina says, don't forget about the 1983 civil suit video. I'd love your insight. Use my teacher. Thank you, Lally, Edwina. And I will put that together for you because the case I was going to cover tomorrow with you of Mr. Patel, who was up on kidnapping charges in Georgia for catching a baby who fell off a scooter, that the mom was riding a scooter with a toddler and a baby in her lap. And she was about to drop the baby. And Mr. Patel, who was shopping in the Walmart, went over and caught the baby from falling off the scooter, was charged with kidnapping. And it came out that the woman who accused him of the kidnapping and the assault, the 911 call was wild. She had also falsely accused someone of a Lyft driver or an Uber driver or something of, grape, let's say. Maybe falsely, perhaps. Yeah, it was in Cobb County, Georgia. Ashley Merchant is the attorney, and the charges were dropped today, right before I was about to go and do the whole case with you tomorrow. We were going to do the bond hearing and everything because, they weren't going to let this guy out on bond. It was insane. It's Cobb County, but I love Ashley Merchant. And I heard a brother counsel did a video today. Go watch it later about the dropping of the charges. So that is, kidnapping. I know it was evil, but so we got some time tomorrow, but that's going to take me some time to prep that case, but I will do it, Edwina. Thank you for your 10. Lally's list of lies, the amount of time and effort it takes for an attorney to figure out last minute if the discovery is prejudicial should be considered unfair prejudice. Yes. And she has other clients, I'm assuming, right? Myles King is not her only client. She's got a small firm and she's got a lot of cases. And I'm still sticking to my opinion that they should have heard testimony yesterday, and I'm still mad about it. I know there's a lot of people that disagree with me, but I don't care. Proctor's affidavit is here and gifted 5 memberships. You're amazing. You're amazing. Yeah, there's video of him, right? He was like, there's video of him, and it's like he had the baby for like 2 seconds and then gave the baby back to the mom. He was looking for the Tylenol or something. It was wild. Thank you, Proctor's affidavit, for gifting 5. You're amazing. Pamela became a new member. Natalie VB Light Breeze. Love your channel, Melanie. Hello from Canada. A lot of Canadian viewers. A lot of Canadian viewers. All right. Let's get back to the papers and let us see what the Commonwealth is up to. Okay. 2 new things hit the docket today. The first is, well, in order of docketing. Okay. So this is something. All right. So in order of docketing, the one that is docketed number 137 is dated August 5th, which is yesterday, which was the date of the second hearing. The one that is docketed number 138, that's how we know that they were docketed on the same day, is dated July 28th, which is a week after that hearing that we just watched. So we'll go backwards because we want to do them in chronological order of turning over to the defense, even though it is not chronologically in the order of filing. So here is docket number, hold on, 138, docket number 138 in the Myles King case. And this is the Commonwealth's Notice of Discovery XXXIV, which I guess is 34, according to now I got to like interpret Roman numerals for you too. All right, let's put Proctor up there in the corner. The newest, well, that's not the newest version. Actually, I have a newer version with sunglasses, but here was the original Proctor that we had because he's the patron devil of the Karen Reed case. And then after his glow down, he now looks like this. But we're going to also look at Howie Carr's article from the Herald this morning, which is chef's kiss. Chef's kiss. Okay. My popularity doesn't know borders. Thank you. Thank you very much, Karen. All right. And Gigi is gifting 5 members again. Gigi, girl, where did you come from? You're my guardian angel. Gigi gifted another 5. Look at that. Dr. Trey getting right in there with a gifted membership, and Christine C. Ms. Wildside. You have to be participating in the chat and you have to be opted into gifts. Cat Q, Stacy, not her mom. Welcome to everyone who is just gifted by Gigi. Gigi's generous. She's changing name to Gigi Generous Gigi. So this is the Commonwealth's Notice of Discovery 34. And this is after the first hearing, but before the second hearing. And here's the things that they just started turning over a week after the hearing, starting with piece of evidence number 391. Now, here's what it says. Now comes the Commonwealth in the above captioned matter. Again, this is Commonwealth v. Myles King. And respectfully states that it has this date provided counsel for the defendant with copies of the following additional discovery material. Oh, Mama Morton is your dream role. Mine too. Mine too, Mimi. That's a great role. Okay. I'm also an actress. Go hit my IMDb page up, you guys, because it helps my star meter. If you know, you know. Click on it once a day, and then it helps my star meter. So when casting directors go there, it makes me look like I'm really popular. Okay. Here's what they're turning over. Now, they're numbered 391. I think the last number in the motion was maybe 360 something. So then there was 30 pieces that must have been turned over before this. So this starts at 391, but here's where it says Bates stamp number 2503. So the Bates stamps, the Bates numbers of the Bates stamps, like a stamp that you stamp, you know, with numbers. Every single page in the file is numbered. So if a police report is 4 pages long, it gets 4 Bates stamps in numerical order so that the court and everyone can easily refer to things by their Bates stamp number. And the Goodmans also gifted 5 memberships, not to be outdone by Gigi. Hello, Brian and Dee. They're the Goodmans. They're awesome. And they watch my show on their date night. Go figure. I don't know. I'll allow it. We love the Goodmans. Thank you. So they're up to 2,503 pages of discovery. Okay. Now, here's what they're turning over as of July 28th, 2025. Commonwealth Notice of Discovery 34, one CD. So it's a CD that they're giving them with all this discovery on it because they still have CDs over there in the DA's office. Norfolk Superior Court protective order for reports as to search of work phone and associated iCloud account by Norfolk District Attorney's Office forensic investigator dated July 25th, 2025. So that has to do with Proctor's work phone and iCloud account. Then they've got a Norfolk District Attorney's Office digital forensic extraction report by S. Vought, V-O-G-T, covered by endorsed protective order. So I guess that's the extraction report for Proctor's phone. Then there's a phone extraction, a Proctor work phone and iCloud account, word search, covered by endorsed protective order, paper number 130. So I believe that, if I recall correctly, Rosemary had to give them a list of words to search in the extraction to see if anything came up about Myles King. You can correct me if I'm wrong, and I know you will. It's hard for me to remember everything. I remember most things, but not every single detail. Norfolk Superior Court protective order for PDF Celebrite reader reports of trooper email and text messages dated July 25th of 2025. ADA Hickman review of Proctor work phone and iCloud account covered by endorsed protective order. Norfolk Superior Court order dated June 17th, 2025. Celebrite extraction of Proctor communication report 7/10 of 21 to 11/19 of 21, covered by June 17th, 2025 order of Judge Doolin, paper number 103. That's interesting to me. That's interesting to me because the extraction of Proctor's phone predates the murder of John O'Keefe. So they've got it. They've got Proctor's communications going back until at least July 10th, 2021. Did we already know this? This was turned over July 28th. Yeah. Did we know this? Or did we just know that they only had it from like 2022 forward? I mean, I guess they got it for all eternity. However far back that phone goes, I don't know. It's under a protective order. Then they have Deputy Chief M. Collins text messages. Okay, well, he's, I believe, with the Milton PD. T-Mobile response emails with attachments for search warrants. So search warrant 303 and search warrant 306. It says attachments previously provided in Notice of Discovery 1, number 53. So it said, okay, this so far is the only thing that it says was previously provided. So you can assume from that all of the other things before that are new. T-Mobile response emails with attachments for search warrant 307. And then T-Mobile response emails with attachments for search warrant 329. T-Mobile response emails, search warrant 348. Item number 405 is a YouTube video, Mizzy Cash, first day out. Mizzy Cash is the rapper name for Myles King, right? Dakota says, I love when karma comes a-calling. Jan Mike 9 wants to know if Proctor's in the Epstein files. Interesting. Karma knows your address, Swiss Miss. That's what I say. Hi, Jody. Mizzy Cash was the rapper name, right, of Myles King. Thank you. And the victim is Marquis Simmons, Marquis. I've heard some reporters say pronounce it Marcus. I've heard some pronounce it Marquis and some pronounce it Marquise. So if anybody knows how he likes us to say it or would have liked us to say his name, please let me know. Yeah, I guess he made a first day out video on July 3rd of 2025. That wasn't so smart. That was previously provided to counsel in hand on July 25th. And there was a Google preservation stuff just happened like after he got out of jail, I guess. So, okay, that's okay. I'll say that that's not late because they just got all of this stuff. Google responses, MSP. So what is this? MSP Case Master Report dated 7/18/25. That would have been dated before his YouTube video was posted. So there's another one. MSP Administrative Report, Lieutenant Matthew Prescott. Unless, they're just backdating things again, the way they did, the way Fanning admitted to in one of the Brian Walsh hearings, right? It's like, yeah, well, I just made these reports last week, but I backdated them all the way back to 2022 because that's what we do. 410, screenshots of contents of bait stamp number 2517. Commonwealth's motion for state court protective order covering materials subject to federal court order dated July 25th, 2025. XOXO, Jennifer Hickman, Assistant District Attorney, Norfolk DA's office dated July 28th of 2025. And then, but wait, that's not all. Plus, if you act now, you can get a set of Ginsu knives. Hang on, because there's more. This was just handed over yesterday. Commonwealth's Notice of Discovery 35 XXXV, docket number 137 in Commonwealth v. Myles King. Now comes the Commonwealth in the above captioned matter and respectfully states that it has this date provided counsel for the defendant with copies of the following additional discovery material. Well, when it says additional, that means to me that they're just turning it over now. And look at what it is. Looky, looky. Starting with number 412, bait stamp number 2559, Milton Police Department custody report dated July 11th, 2021. Milton Police Department incident report dated July 11th, 2021. This is what the Milton police officers were going to be questioned about, why they didn't turn this stuff over. Allegedly, they might say, we did turn it over. We gave it to Lally. Number 414, Milton Police Department incident report dated 7/11/21. And then Milton Police Department incident report dated 7/11/21. Slideshow notes. Not sure what that refers to. That's number 416. And then 417 is Milton Police 911 radio transmission. 2021 production, 32 items. 31 items previously provided in Notice of Discovery 28. So there's an extra one that they just gave them. And doesn't that remind you of something? Doesn't it remind you of how they had lots and lots and lots of Sallyport video with regard to the Karen Reed case when her Lexus, the alleged murder weapon, was in their custody. And they just turned over little jibs and drabs, bits and bytes of the video. And then more videos started magically appearing after the first trial. And they turn over some, but not all. They hide some in a drawer. Meanwhile, a man sits in jail, right? Number 418, screenshot of contents of bait stamp number 2571. 419 is the federal court order of July 21, 2025. Provided in hand to counsel because we gave them something on the 25th. Federal court order dated December 2nd of 2024, covered by endorsed protective order. 8 pages provided in hand to counsel. 7/25/25 XOXO. Jennifer Hickman, Assistant District Attorney of the Norfolk DA's office, dated August 5th of 2025. So how in the hell, for the love of the traveling Mary, is Rosemary Scapiccio supposed to make any charts about anything when she certainly doesn't have all the discovery? And they continue to turn over discovery as of yesterday. And Jennifer Hickman is the attorney who was subbed in for Adam Lally after he was taken off in something like November or December of 2024. Are you shocked? Yeah, I think Kel wants to know. I think that is the federal court order that she was waiting for. Yeah. So, who knows what's in there? Who knows what's prejudicial and how prejudicial it is? But the judge wasn't going to let anybody testify yesterday. And he did say, we're going to continue it until, I think he said the 13th, right? But he said the 13th is not going to be an evidentiary hearing. You're just going to come report back to me and tell me if you made my charts for me. The 13th, wait, no, the 13th is when Aiden Carney is in court. Sorry, it's the 12th. I have it down as a non-evidentiary hearing, 9 a.m. on the 12th. And then at 2 p.m., he's going to hear the motion for all the cases about the sealing. The destruction of Proctor's text messages that relate to all of the cases. Marianne said, I'm going to be like Nurse Kim and clutch my pearls. So yeah, it is the 12th. And the Commonwealth's motto says al dente is what they don't know won't hurt them. Yeah, it's the 12th. Sorry, I was wrong. I had to look at my calendar. It's the 12th. Aiden Carney is in court on the 13th. It's a busy week next week. But this may be another nothing hearing because, they don't have to do anything. Apparently. Thank you, Virginia. You're the best. We've been together for 16 months. Boston Girl gifted another membership. Charissa, you're very generous tonight. Thank you so much. And always, Mrs. Diesel Dude says, after 4 years, shouldn't it just be presumptive prejudice? I don't even know if that's a thing. Just the length of time seems prejudicial to me. Yeah, well, it could be prejudicial, but not so egregious or so prejudicial as to lead to a dismissal. That is a very, harsh sanction. But, when are they going to learn over there? Because there's never ramifications for their behavior. Thank you, Ms. Diesel Dude, for your 10, because they just do whatever they want. No, it's not Friday the 13th. The 13th is actually, Wednesday. So the 12th is Tuesday. We're coming back on this one. See you next Tuesday on this one. And then Turtle Boy's case on Wednesday. Kick the can. Let's just keep kicking the can down the road. And Cherie is here, and she gifted a membership too. You're awesome. Take a look at this. Take a look at this. Today's cover of the Boston Herald. For some of you, it's behind a paywall. Some of you may not have seen this. Some of you may have seen this. But if you haven't, here it is. Thank you, Cherie. Appreciate you. Righteous decision. Here's a picture of Jeffrey Noble. He's the new MSP boss. Tossing Proctor was the right move, it says. There's a picture of Proctor. Then Howie Carr's article of the day, his column is called Porky Proctor's Just Desserts. Don't worry, because we're going to read it. Because you probably want to hear it, right? Nothing like a little Melanie, little ASMR to get you in the mood for bed, right? Okay, hang on. Let me make it big enough so that I can actually read it for you. First up, excuse me while I take a sip of my drink. I had another comment yesterday about how I really like Melanie's content, but she's so loud when she sips her drink that it is absolutely unbearable. I wish I could find someone else who didn't do that had such good content. You guys know that I always mute my mic when I sip, right? Of course you know that. I am very, very sensitive to my misophonia friends. I didn't even know that misophonia was a thing until I started a YouTube channel. I'm sorry. I just didn't know it existed. I'm really sorry. But you know, I always mute my mic. Okay, here we go. People are just going to always complain about something. Hold on. Okay, here we go. Noble firing Proctor, righteous decision. And this is written by Flint McColgan, who writes a lot of articles about this case for the Boston Herald. The head of the Massachusetts State Police says firing Michael Proctor was a righteous decision and that he doesn't expect the former trooper's appeal to the Civil Service Commission to succeed. I'm confident that the civil service process will work itself out. And at this point, I have no reason to believe that they will see things any differently than we saw them, MSP Colonel Jeffrey Noble told the Herald in an exclusive interview Tuesday. Noble said, "I can't and I won't make any opinions yet on future Civil Service Commission decisions," but added that he respects the process. "I'm very confident in the fact that we had a process here within the Massachusetts State Police," he said, "and that through that process, when we ultimately gave the order to separate Trooper Proctor from service, I felt that was certainly a righteous decision and certainly in the best interest of the Commonwealth and the Mass State Police." Noble was hired last September to lead the MSP. He came from the New Jersey State Police, where he had most recently served as Deputy Superintendent of Administration. He said, however, the majority of his career was as a homicide investigator, so he understands the unique pressure sometimes and the unique challenges and the unique exposure that come with homicide investigations. I don't know. I know some retired law enforcement that would say that every homicide investigation should be done with honor and integrity. Shouldn't be difficult to do that because nobody hates a bad cop more than a good cop. Right, kindergarten cop? Quote, "My assessment is that our detectives that are out there by and large are doing a very good job," he told the Herald. "That said, I'm eyes wide open to a culture issue that I have concerns with," he continued, "as it relates to what we saw with Trooper Proctor." That's right. Kindergarten cop, 25 years on the job, NYPD. Boy, were we on it today with that Montauk thing, huh? Both of us fell into the rabbit hole together. I'm like, I found out that she was getting divorced. And he had a lot of info too. We love Kindergarten Cop, one of our amazing moderators, as is Little Cupcake. Shout out to Little Cupcake too. Don't forget Little Cupcake. And Scott Messerschmidt is here as well. He's awesome too. And whoever else, there's Scott Messerschmidt. He's awesome. They're doing the Lord's work, you guys. That's why this is such a fun place to hang out, because it is a volunteer job that is very hard to do. So thank you for your service, all of you. Your service for not only with the NYPD, but for me. Lisa, the turtle boy sips loud on purpose when people complain. It's crazy. Okay, moving on. The firing. Those concerns came to a head earlier this year when the agency fired Proctor, the lead investigator in the death of Boston police officer John O'Keefe, a case that led to murder charges against O'Keefe's girlfriend, Karen Reed. Well, it's still a murder case. It's just Karen Reed didn't do the murder. Flint. When Proctor took the stand in Reed's first trial, he was forced to read text messages he admitted were unprofessional and regrettable, sent to both colleagues and old friends. In them, he referred to Reed as a babe, a whack job, and other names too offensive to print, mocked a medical condition she suffers from, and shared case details with people lacking clearance, telling them, quote, "There'll be some serious charges brought on the girl." Proctor also texted I can't get enough of that picture with those sunglasses. I think we need to continue our playlist. Cheap sunglasses needs to go on there. Isn't that like ZZ Top or something from back in the day? Cheap sunglasses. Okay. Proctor also texted his sister that he hoped Reed kills herself. Proctor, who earned $184,000 pay in 2023, according to state records, was placed on leave immediately after the first trial ended in a mistrial and was fired in March before Reed's second trial. Was it worth it? 184 large to ruin your life? Somebody'd have to pay me a hell of a lot more than that to blow up my whole life, and my family, and my livelihood, and my job, and my honor, and my integrity. Not nearly as much as, I don't know, Gallagher. Some of those guys are making well over $3 billion a year, right? The MSP trial board found him guilty of 4 specific violations of the agency's rules of conduct, 3 of which directly tied to the Reed investigation. The findings concluded that his text messages were both derogatory, defamatory, disparaging, and or otherwise inappropriate, and often provided sensitive and or confidential information to non-law enforcement personnel. They also found that his unprofessional and inappropriate conduct brought himself and the Massachusetts State Police into disrepute. The final unrelated finding was that he drank alcohol while on duty and drove his cruiser afterwards. Yeah, they didn't go on, but we know the details of that. He was with, guess who? Kevin Albert, the brother of Brian Albert, the owner of 34 Fairview Road, who was a Boston police officer. Kevin Albert, Canton police officer. Him and Kevin Albert were working a cold case, in air quotes, down the Cape after the murder of John O'Keefe. I think it was in the summertime. I want to say July. And the next morning, Kevin Albert texted him something like, "Dude, where's my gun?" I'm summarizing. Or something like, "I'm really hurting this morning. Dude, where's my gun? And my badge? Can't find either." Proctor said, "Well, I'm summarizing, haven't seen your gun, but your badge, you left your badge in the cup holder of my cruiser." And he said, "Okay, dude, can you drop it off in my mailbox, man?" He's like, "Yeah, sure, man. Whatevs. No big whoop, no biggie." I don't know whatever happened to the gun, but I would submit to you that's probably the bigger issue than some text messages. But everyone likes to say it's ridiculous that he got fired over some inappropriate text messages just because he was really, really mad that a fellow police officer was murdered. Are you forgetting about the "dude, where's my gun" thing? Because, there was that. Proctor's attorney, oops, that's my cursor on your screen. Please do not break your TV and send me a bill. That was my cursor. It's not a fly. Proctor's attorney immediately vowed to appeal the discharge to the Civil Service Commission. The appeal is ongoing with the next hearing scheduled for later this month. We listened to that. Well, I listened to that on Zoom the other day in real time and repeated what they were saying to you because they threatened me that nobody could live stream that Civil Service Commission hearing. And then they locked the room so nobody could even get in. Even if you had the code, you weren't allowed to get in. They locked the room. But they did say, somebody in the chat said that you could go there in person. So if you want to go there, I think it's the 25th and 26th or 26th and 27th or something like that. Proctor's family also released a statement that they were, quote, truly disappointed with the trial board's decision and that the messages prove one thing, and that Michael is human, not corrupt, not incompetent in his role as a homicide detective, and certainly not unfit to continue to be a Massachusetts State Police trooper. Nanny, poo-poo. Really? Is that what all human cops do? Because most cops, unless we don't have robo-cops yet, do we? Most cops are human. I would submit to you that most law enforcement not doing that kind of thing. But, what about the drinking and driving in the police cruiser? What about that? Drinking on duty. Is that okay? Because read the room. Exactly. Likewise, State Police Association of Massachusetts President Brian Williams issued a statement that the department decided to sacrifice Trooper Proctor to appease the media. Oh, really? Oh, really? Because let me tell you something, because I've been here the whole time. I've seen this film before. I did like the ending of the second film, the As Such Season 2 ending. I liked that ending, okay. But we saw this film before. We didn't like the ending, and none of the local media were on the side of Karen Reed. You know it. I know it. Took a hella long time. The department decided to sacrifice Trooper Proctor to appease the media. What do you think? Reed was ultimately acquitted of murder, but jurors did convict her of drunken driving. Really? Drunken driving? Well done, Flint. Well done. Yes, Tracy says, local media is bull, says Andrea. Or shite, if you prefer. It's feckin' shite. It is feckin' shite. Scooter 54 said, I wrote to NBC 10 about that. KBD said the public wants them all fired. The public, right? Not the media, though. It's not about the media. It's about the public, I think. I don't think it had anything to do with the media. Right. Laura says, but do they include Turtle Boy in the media? No, they just call him a blogger, which I think is defamatory in nature, but you know, it's just me. Christy, a painter's daughter, says, always explaining all the legal stuff to us. Thank you for being with me for 15 months, Christy. Tony says, Proctor is going to go to the proctologist. Haha. Melanie, you are the patron saints of all the papers. Oh, I'll take it. I'll allow that. Patron saint, the patron. I called Dr. Marie Russell the matron saint of the Karen Reed trial. We had that. I'd love to interview her. Maybe I'll reach out to her too. Giving me ideas. Kelly Reed is Bill Reed's cousin. Somebody said, is Kelly Reed Karen's sister? Kelly Reed is Bill Reed's cousin. Bill Reed is Karen Reed's dad. So she's cousin Kelly. She's our cousin Kelly. And I love her with all of my heart. And if I don't see her soon, I'm going to die, Kelly. So Kelly, this thing that you sent me, is that something you want me to watch? You want us to watch that on the air? Mm-hmm. Oh, I remember this. I remember this day. Should we watch this and start at 24 minutes? Okay. All right. Let's do it, Kel. Let's do it. You guys want to do it? Kelly's contributing to the show today. One of those days from pre-season 1 of the Karen Reed Show. One of those times that Lally lied to the court. One of those times that Judge Cannoni did nothing, didn't even flinch. And Lemonade says, should I leave it in the mailbox or at the gym? Oh, is that what he said about the badge? Thank you for being with me for 10 months. I think I thanked Cherie, but I can thank you again. Thank you again, Cherie, for gifting a membership. And Ryan says, Proctor's right. He's not being treated equally, but being looked at by the FBI gets special treatment. If MSP could have ignored it, they would have. Well, the world is watching now, Ryan. Look, you're from Canada. You know what I'm saying. The world is watching. You're all here. You're all watching. And the world is paying attention now. So it's crazy. It's crazy to me that Judge Krupp is like doing what he's doing, because does he not know that the world is watching? And really, I mean, maybe I should just start shutting up, because they're just going to stop letting us. They're going to stop letting cameras in, and then what? Oh, shout out to Canton Community TV, also doing the Lord's work, because before anybody was really paying attention, besides Aiden Carney, to the Karen Reed case, Canton Community TV was in there recording the hearings. And that is why we have some of the hearings recorded from back in 2023, because mainstream media wasn't paying attention back then. I'm sure that back in the day we covered this, but this is from September 15th of 2023. This was a motions hearing. September 15th of 2020. Wow, this is back in the olden days, you guys. This is the lore. For those of you who weren't here for season 1, you're going to see this is some lore. Memories line the corners of my mind. Look how young and fresh everyone was. This is the beginning. I'm going to go to 24 minutes when Lally starts lying.
All parties having anything to do before the Honorable First Justice Dudley, now sitting in the Norfolk Superior Court, and for the County of Norfolk. Draw the end of your attendance, you shall be heard. I'll say the Commonwealth and this with court. Thank you for this.
Okay, so look at this. So here's Aiden Carney right back here in the suit jacket. See where my cursor is, and he's standing right kind of behind Mr. Reed and Mrs. Reed, and Nathan is there. I'm sure Kelly is there somewhere, but we can't see her. Look at Liza Little's hair is long. Alan Jackson is clean shaven. Karen's hair is straight, and David Yannetti, his normal, amazing self. And then in the front row, attached to the judge's bench, is Adam Lally and Laura. Okay, I'm going to give you a trigger warning. If you have misophonia, mute your microphone right now. Laura McLaughlin. Clerk Jim. Let's go to 24 minutes in. It's about an hour and a half long. I mean, we could watch it if you want, but this is pre-Alessi. This is pre-season 1. This is September, what did I say? September 25th, 2023. September 15th, 2023. Let's go to 24 minutes. I'll start at 21 minutes. Oh, look who it is. Smooth as butter. Smooth as butter, Alan Jackson. Oh, we have an emoji for that too. Queen Tanis is there too. Queen Tanis. Tanis is my queen. She's David Yannetti's sister, Queen Tanis. And hey, if you're out there, and Mrs. Yannetti also watches. Love them both. This is the hearing from September 15th, 2023. And this is when Lally was lying. So Lally's played this game before. So we have a smooth as butter emoji for the members. I mean, if anything, if you guys want to join, it's fun. We have special emojis and we have a lot of fun here. So, YouTube says that if I mention memberships in the video, you get 3 times more members. I don't know if that's true or not, but they try and nickel and dime you all the time for everything in the tubes of you. So let's take this back a little bit. Buckle in if you've never seen this BS. Oh, there's Queen Tanis. There she is right there on our screen. Queen Tanis Yannetti. She came to court one day when David had a medical appointment, and she ran that courtroom like nobody's business. It was amazing. And then when he came on and did the interview with me, he and Bob Alessi, he remembered that. And he said, "Thank you so much for calling her Queen Tanis. We love that so much." BB before Bobby. And look at the baby shark hairdo in its full effect. There it is. Baby shark. Do. Baby shark. What kind of product do you think that is? Do you think that's like the gel? Or do you think it's like Dippity Doo, Mousse, Putty? Yeah. Tanis is in the black right here.
As it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party.
Do you want to start from the beginning? Or should we start? Because it's 24 minutes in. So let's start from the beginning, just so you can get at a bit of the lore. And 24 minutes in is when he's going to start to lie. But I think we kind of need the context, right? LA looks, that's it.
All parties having anything to do before the Honorable First Justice Dudley, now sitting in the Norfolk Superior Court, and for the County of Norfolk. Draw the end of your attendance, you shall be heard. I'll say the Commonwealth and this with court. Thank you for this session. You may be seated. Good morning, Your Honor.
Good morning.
This is the Commonwealth versus Karen Reed, docket number 22CR117. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Attorney David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Alan Jackson for Ms. Reed. Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right. So today was, originally it was just scheduled for status on the motion to compel. And you'll remember that last time I did ask you to put in writing exactly what was still outstanding and when you thought that you would get things, Mr. Lally, to the defense. So since, and we will do the motion to compel, but since that time, counsel have filed additional motions. So there have been, what I understand, what I have is 2 Rule 17 motions filed by the defense, one essentially for records from the Canton Town Clerk regarding the plow. Was that Zoom, Jim?
Oh, yeah. Is this the Zoom one where they talk about
the
Free Billy Civics?
second is the motion for the Google Nest of the homeowner here. 3 filed by the Commonwealth, footage regarding a motion for the video footage from the defendant's father's home. So whoever's on Zoom, you have to be muted or we'll throw everybody off.
They forgot. They didn't know how to mute people on Zoom. This is, oh, wow, all the way back in September 2023 before they learned how to work the Zoom.
Motion for records from ABC and NBC, essentially.
Listen. She keeps stopping because the Zoom people are talking. I thought they were frozen, but Lally's just like a statue.
I think I can take care of it. Thank you.
Okay, thank you. And then there's a recent motion regarding exhaustive testing. Then there's a motion for me to review conditions of bail. And we're also going to set a scheduling order because these piecemeal Rule 17 motions coming in where an affidavit had been in possession of counsel since January 2022. We're not going to keep doing that. We'll set firm dates from here on. So before we start with the motion to compel, have the third-party record holders been given enough time? Have they been notified, Mr. Lally?
So yes, with respect to each of the respective 5 Rule 17s from both the Commonwealth and the defense, I did send notice to all the third-party subjects and all the third-party record holders.
Okay. Did you get any responses from anyone?
The only response I received, Your Honor, was from Attorney Gregory Henning, who represents Brian Albert in reference to the Google Nest situation.
The defense had Rule 17 motions to get Brian Albert's Google Nest records because they say he had a camera. He says he didn't. And I think this was also around the time where they were looking for Jen McCabe's Google searches. And they were looking for, I think, Brian Albert's some cell phone records for him also. And isn't Greg Henning a reporter with one of the local stations or like the legal analyst on one of the local stations? This was in the big courtroom. Wow, this is like the olden days. This is like, it's like how my kids can watch like every season of Grey's Anatomy 100 times and they're always watching Grey's Anatomy over and over and over and over. It's like, I'll never get tired of watching this. Wow, if we knew then what we know now, September 2023, and they're still withholding all this discovery, and it's almost 2 years after the murder of John O'Keefe, and they can't get like DNA, and they can't get so much stuff. Oh, thank you, Patty. Greg Henning is WCVB Channel 5 legal analyst. Thank you. All right. So you know why their coverage was skewed? Because they represent Brian Albert. Bob Weir's here. Bev, the entire world wasn't watching you at this point. She sounded so confident back then. Bob Weir, if you weren't here for the show that I did at whatever time it was earlier, right before this one, 6 o'clock, there was a woman found dead on a boat out in Montauk. The boat is called Ripple. It's got a Steely on it. And it's out of Long Beach, New York. I don't know where you're from, but this doesn't bode well for us deadheads. Okay, moving on.
Okay. Does he want to be heard?
I believe so, yes.
Okay. Is he here today?
My understanding is yes.
Oh, okay. Good morning, Ms. Henning. All right. So it makes sense then to start with the Rule 17 motions. Nothing from, were the record holders given enough time, Mr. Lally?
As it pertains to the Commonwealth motions, yes, I did receive this latest one just late last week. So as soon as I received it, I sent notice. But so it's been at least approximately a week or so that they received notice.
Okay. Does the defense have any reason to believe that there are record holders who haven't been given enough time and you expect them to be in today?
Your Honor, with regard to it, let me just step up. That might be easier. Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from.
There's Eugenia.
Or with.
Eugenia is there. Oh, look, there's Aiden right there with his hand on his face. But wait, if we go back like a little tiny bit, there's Eugenia. I used to like Eugenia, but then she wasn't very nice during Aiden's trial, so I don't think I like her anymore. Wait.
Let me just step up. That might be easier. Your Honor, if the court could define which of there's multiple motions.
There she is. There she is, holding guard right next to Aiden, by the way, in the courtroom, standing guard in the middle aisle.
From the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about?
I'm talking about all of them. Do you have any reason? Mr. Lally sent that he sent out notice to all of the record holders pursuant to Rule 17.
Right.
And that he only heard back from one person. I know some of these motions were filed late. So my concern was that some of these record holders did not get notice. Yes.
Just one addendum to that, Your Honor. I did also speak with counsel for the town of Canton, and they have no objection to the records. Not the Commonwealth, but I did speak to her as well.
Okay. Does that answer your question, Mr. Jackson?
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17 B motions on, I do have an issue with because I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities.
Did you speak to legal counsel? Because that's where it went, right?
Correct.
I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
Mr. Lally, I don't want to continue this Rule 17 motion hearing, but what's the Commonwealth's position on that?
The Commonwealth's position is notice was sent at least 2 weeks in advance of the hearing date on those motions. I haven't heard anything from either of those parties. It was addressed attention to legal counsel for those entities. If the court wants to push it off to a further date for me to provide additional notice, I'm okay with that. But at the same time, I don't foresee being any issue. And obviously, if the court were to allow the motion and order the records and there was some objection to them, certainly no records would have to be produced until at such time as they could be heard.
All right. What I'd intend to do is go forward on the motion today. I will, in all likelihood, take it under advisement. And
right, because she can't decide anything from the bench.
If we hear from them that they did not receive notice, or they get late notice, or they want to be heard, I can reopen it. So
that's satisfactory with us, Your Honor.
All right. So since you have, the one that seemed the quickest to resolve is the Canton Town Clerk motion. Mr. Clerk, that's paper 116.
Thank you, Your Honor.
Canton Town Clerk. Oh, that was for the
So in
Chloe
reviewing
records.
that, I sort of assumed it was something that the parties might agree to, and you said
that was for the Chloe records. They wanted the records from the town clerk, right? Wasn't that the animal control clerk? Let's listen.
The Commonwealth agrees to that, Mr. Lally?
No objection, Your Honor, no.
Okay. All right, so I will allow that. I'll take a closer look at the proposed order. That motion will be allowed.
She allowed it. They had a fight to get the records of Chloe from the town animal control clerk. And this
All
is
right,
already
Mr. Clerk, I'm
September
going to hold
2023.
on to that to take a close look at the order.
All right, so
The sound just got better.
116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party?
Oh, yeah, you'll recognize him when he comes up from being on Channel 5.
Okay. So why don't I hear first, I just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there. Why don't I hear, I guess you'll have to take a seat. Why don't you just sit back? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think.
Look at Turtle. It's like,
I have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself, but
just in case you didn't know, if you're on a grand jury, the grand jurors are allowed to ask questions of the witnesses who are testifying in front of the grand jury. The grand jury is a one-sided proceeding. The defendant does not participate. The defendant is not there. Their attorneys are not there. Oftentimes, they don't even know that there's a grand jury being convened to try and indict them for something. It is a one-sided proceeding, and the grand jurors are allowed to ask questions. And he's saying Lally questioned him for hella long time, never asked about the cameras, and it was a grand juror who asked Brian Albert if he had any cameras at his house.
this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client.
Let's hear.
It will save us some time if we direct it to the order if there's no objection.
I do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm going to ask you to have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Greg Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in mind, that language, Mr. Albert, the homeowner, has no objection to the Rule 17.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage.
How does that make sense?
And I question whether or not that was a...
When they say He was hit at who knows what time, 12:31, 12:34, 12:36. They kept changing their theory on the 29th. They're agreeing to let them have the Google Nest camera footage or records up until the 28th. How does that make sense? How does that make sense?
As the
Did you see number 3 of their proposed order?
proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number 1 says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
But obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor. We both received it. I mean, I can read it on my phone as well as I can read it on the.
But didn't he say something like the Google Nest camera
My
was
issue
never set up
is,
because he
as
got
I
it for
indicated,
Christmas
I
and never
wanna
set
make
it up?
sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and
set it on the stand.
encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number 1 that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number 3 is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number 1, excising any sort of other Google account information. Which
And I
is
think Mr. Jackson
relevant.
just said he didn't have an objection to that. All right.
That and expanding the time frame. That's
Okay.
The only wording that was changed under number 1 that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, and he set up inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of the Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. If the sum and substance is that we get the Google Nest data, that's what we're concerned with.
All right. And you'd prefer that I add the expansive time frame than the
Correct.
less restricted time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. We're going
to move it a little bit to like around 24 minutes is when Kelly says that he starts lying, let's say.
by way of letter of legal counsel as to why they did not appear here today. And then we can see about setting up a hearing. If your position is that you don't object to it. Is there an objection to the exhaustive testing motion?
At this point, Your Honor, there is.
Okay, so we'll hear the
There's some
motion.
technical reasons, but
We'll do the motion to compel first.
thank you.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received.
Here he
I did
goes.
receive a packet of information today, but I'll go through that with the
Today.
court.
He does that.
Okay.
He does that. He turns stuff over the day. On the day of the motion to compel that is going to be heard. And yes, Oh Sweetie No says, hey, remember when she used to occasionally grant a defense motion? She even mentioned a hearing. Yeah. And then you know what she did on the day of the hearing? She canceled it. She canceled it because Jennifer McCabe was going to have to testify and Brian Albert was going to have to testify. And I think, was it even Higgins who was going to have to testify? And she canceled it. Remember? I do. All right, here we go.
So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12th, 2022.
They've already had one.
The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time.
I see a lot of chatter about Rule 14 in the chat, and Rule 14 was not changed until after Karen Reed's first trial. So this is still old Rule 14. When Rule 14 was changed, guess who was the chair of that committee to change Rule 14? It was Judge Beverly Canoni. It was after the Karen Reed's first trial. So this is old Rule 14, but great questions. You're paying attention.
And we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote.
Okay, here's where she's going to point out all of Lally's lies and all of Lally's unfulfilled promises. Feels like we've been here before. The playlist is still linked underneath, by the way. We still have the playlist. We got to keep it going, I guess.
I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see.
What are your grave concerns
Quote,
now?
Note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report.
Closed.
And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hand.
Well, would this all be just cause for his firing? Because he keeps lying and keeps lying and keeps lying, and the crime lab apparently keeps records, and they keep track. So who's lying now? Who's lying, Lally? Were you lying then or are you lying now? Is the crime lab lying or were you lying? Who's lying, Lally? Nobody seems to care. There's no grave concerns, though. We'll keep watching.
Hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires.
Turtle Boy shaking his head as all of
That brings
us.
me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexus infotainment system and the Lexus telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that.
Do you want to respond, Mr. Lally?
The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Staunton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order. The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road
Oh.
that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022.
But wait, there's more. Letteros by Betterow. I hope Rosemary Scapicchio is watching this right now because she needs to use this as evidence against Adam Lally. Because I don't know, was he too involved in not turning over discovery in the Karen Reed trial to not turn over discovery in the Myles King case too? Letteros by Betterow says that's why the King hearing was so important. Lally needs to be held accountable for his behavior. No one does anything about it. Why would he change his ways? That's right. That's right. She's lighting him up for his lies. And let's see if the judge has any grave concerns about this.
But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview.
That's right.
That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No
Didn't make
notes,
'em.
no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene.
No.
That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date.
This is the first time. Thank you, Scott, for reminding me. This is the first time that the public was ever made aware of the taillight harvest days, as Scott McGinnis is calling them. He says, this is the day Liza revealed the taillight harvest days previously unknown to the public. Yeah. They didn't tell the defense team until 18 months after John O'Keefe's murder about all these other days that they started finding taillight pieces. Isn't that convenient? But wait, there's more. So if they didn't even tell the defense team for 18 months, when do you think those evidence envelopes were filled out? I think the dates on them were accurate. There was no chain of custody documents, no notes, no police reports, no photographs, no measurements, no nothing. And they didn't even tell the defense about it until 18 months after. And this is when we learned about it, the public, for the first time in September of 2023. You should be outraged still.
Notes and reports so that we can at least attempt to prevent further fabrication of evidence.
Yeah, fabrication. You
The
go,
fifth
girl.
category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case.
He does it in every
So
case.
I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you.
Okay,
Lally?
thank you. No concerns. Connie Goudreau, you're not
Your Honor,
related
I'm not
to.
quite done.
Oh, you said there were 5.
She's not finished. Connie Goudreau says, I can listen to you. I listen to you every night. I love your sense of humor. Thank you. I wonder if you're related to the Goudreau brothers. And if you are, my deepest sympathies. Johnny Hockey. Very sad. Still about that case. Okay. Yeah, she's like, yeah, you know what, Judge? I'm not done. This has been going on for at least 3 decades. At least. You're right.
I was going to have a conclusion if I
Okay.
finish addressing the court. Thank
Sure.
Sure.
Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Come on.
Yeah, sure.
Get to the podium, Lally. You
Most of what I
wuss.
believe was just addressed
A wuss.
was dealt with in the Commonwealth's response.
Put your big boy pants on. Put your diaper on. Get your binky out of your mouth and go back to the podium like a man, okay? Or a woman or a real lawyer. A real lawyer would not stand with his back to defense counsel from his bench that's attached to mommy's bench and make his argument. Let's see if she makes him go back to the podium, and let's hear the lies and count the lies as they come out of his mouth.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
She was going to allow him to stand there. Yeah, she said, we can't hear him. Could you make him go to the podium? And the judge actually backs him up and says he's talking into a microphone, but I guess if you can't hear him, I'll tell him, Lally, honey, baby, sweetie, baby, can you go back to the mic? Go back to the podium. Just, watch my signals because I can't do it to you while you're here. You just have to, say no more. If you can't hear him, right, Wendy? If you can't hear him, I'll make him go to the podium.
I believe most of this I've addressed.
Look at the smile on Turtle Boy's face.
And just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule 14. It does not oppose the defendant having access to these items. It's merely an issue of timing. Now,
I'm sorry.
as it pertains
How about your lies?
to the first enumerated item, and there's been various modifications of this. And what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4.
Word salad.
As it pertains to
Got an emoji for that.
reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing.
But we've given you 300 pieces of evidence, but it doesn't mean we're withholding anything. But he's not addressing his lies. You lied to the court when you said that you spoke with the crime lab in February, and that it's forthcoming. They closed their file because they never heard back from you, and they've got no record of you calling them in February. Just because you turned over a whole bunch of stuff doesn't mean you've turned over everything. And again, you're lying to the court. Is she going to call him out on his lies? Let's see. I think I've seen this film before, and I don't remember the ending, but I'm pretty sure she probably won't.
The defendant from receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some point in the history of this case where I have been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson.
Bullshit.
My remedy for that has been to provide whatever.
Yeah, I've been giving it to Ms. Yannetti. Oh, hold on. I got a bullshit button. Hold on. Here it is. I've been giving it to Mr. Yannetti, but he hasn't been forwarding it on to Mr. Jackson and Ms. Little, so that's their fault, Your Honor. What's the name of that song? I Know You're Lying because your lips are moving. It's like a Meghan Trainor song. That needs to go on the playlist.
The Commonwealth is I would submit, withholding evidence or preventing the defendant from receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some point over the history of this case where I had been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson.
Your lips are moving.
My remedy for that has been to provide whatever I can, especially documentary evidence and attachments, email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then there was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel.
Turtle Boy's face.
What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as...
There he is, Shaggy. It wasn't me. It wasn't me. It wasn't me. It's the lab's policy, not my policy. It wasn't me. The exhaustive testing, they wanted to do exhaustive testing, I believe, you guys can correct me if I'm wrong, I know you will, on the hair, the apparent hair, because whatever DNA testing I think they were going to do to the apparent hair was going to destroy the hair, and then no further testing could be done. I think that was the exhaustive testing that they were talking about, right? Turtle Boy's looking around like, is everybody else hearing this? If you're just tuning in, we are watching the September 15th, 2023 hearing with Lally lying to the court about his discovery obligations and what he turned over and what he didn't turn over, going back to before the first persecution of Karen Reed, before the first trial, to show Lally has a custom and practice of doing this, just like he's doing in the Myles King case. Boy, your lips are moving. I just put it on the list.
Anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense
You're just
and we're
lying.
afraid of what it might show is just patently ridiculous. The items that are at the lab are, there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual units from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that.
I'm sorry.
Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing.
Oh, here's where we got the shards of taillight in Mr. O'Keefe's clothing. This is where the lie began. And the Twidiots ran with it. And they were like, but Lally said in open court that there were shards of taillight that came from his clothing. And then when we learned that they were scraped all into the same envelope by, I think, Maureen Hartnett, with maybe some pieces of taillight that were already in there. I don't remember because this is giving me such PTSD. Boy, he sure can read fast at lightning speed. He can read numbers at lightning speed, says Eisenberg. But yeah, this is where he wanted everyone in the world to know they found microscopic pieces of taillight in the clothing. Hold on, I got to take it back. Again, this doesn't explain why you didn't tell the defense until 18 months later that taillight was found on how many different days. Because there's no reports. He said a lot of things in open court that were not true. You're right.
Passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual units from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery, or analysis. There was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab
This is where it started.
theretofore thought that they were had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle.
The bumper glass.
Comparing it to pieces of what they describe in the lab notes as a cocktail glass.
Remember, that glass on the bumper did not match the cocktail glass. Let's see if he lies about that now.
Found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the waterfall bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing, my understanding, should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed.
See how gaslit we're
DNA
being?
testing, I anticipate,
All the way back in September 23.
on or around September 26th. Those 2 trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly.
Shortly.
It's
been almost 2 years, you jack off. This is called gaslighting.
As far as whatever the
Gaslighting at its
court,
finest by
deems
Massachusetts
appropriate.
prosecutors or persecutors. We call it gaslighting. Josh H. says, listening to this and Lally's testimony in King is making my mind explode. This guy is such an unethical prosecutor. Wow. Not one interruption, Cherie says. Yep, not one.
To impose. Obviously, the Commonwealth will comply.
Thanks,
with
Josh.
that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it would be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab. But if
They sent Bodie Labs they sent a bill to Karen's. If you want to come watch the testing, you have to pay $22,000 just to observe the testing. 22 grand. Look at Charissa gifting another 5 memberships. You're amazing, girl.
there are any items that have no forensic value
22,000.
left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time,
I don't know.
It depends on what the other testing shows. So it's typically what the
Depends on
lab
what we
is
can
going
rig.
to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone and is just about to be undergone or is undergoing currently,
Undergoing,
I can't speak
undergone.
as to what those results
No
would
big
be,
whoop,
and,
no
and
biggie.
therefore I can't speak to whether or not there would be any need for additional testing.
No grave concerns.
Okay.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion that compels, it's sort of incorporating
You're
all kinds
confused?
of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should counsel have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to counsel. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the car's unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that
this
I'm
is normal
aware of
speed.
that
Yeah.
pertains to those
It's like-
types of systems. They receive updates periodically from the manufacturer. I believe there's another one coming up.
Oh my
in a month.
God. Who was it that chased, was it Garino? That chased the Burla rep down at the sales conference and was like, when are you going to make the software that's going to make it possible for me to download the stuff from this Lexus? Was it Garino? Dude, where's my car? All word salad. Lying with every breath. This is where the lie came out about the microscopic pieces of taillight in the clothing. The bumper glass, September of 2023.
So, but I have no information. We reached out to Berlin numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up and until we receive an update that can actually read and parse the data that's contained therein, it's
lying
an issue as far as
King,
there's
like he
been
lied
data
here.
that we've extracted and we provided to counsel, but it's essentially unreadable data at this point. I am aware that Trooper Garino from our office spoke with counsel's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just
He just
pertain
keeps
to the
lying and
borough.
lying and lying and lying and lying and lying and lying. And what does the judge do about it? Nothing. Nothing. And there's never any sanctions. Never.
Motion or not, the Commonwealth has no issue with
His ears get so red when he lies.
to abide by its duties and obligations under Rule 14. Whatever discovery I
Just
have,
cutting lies
or
off,
whatever
right? And he
discovery
gets to
that I
talk
can
about
provide, I'm happy to do so. That is.
How about the lies?
Okay,
About the,
Ms. Little, any follow-up with that?
if he stops lying, he'll forget his train of
Mr.
lie.
Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what
Right. I think the destructive testing also applied to the chip off, right? Fast forwarded through that part of his blather.
particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so
it.
after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the two experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches,
Yeah, the
we
taillight.
don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from
Allegedly.
somewhere. So
They
we need
backdated those
reports on
envelopes
this.
too, you think?
And with that,
What do
I
you
will
think?
submit, Your Honor.
What, the over-under? What's the over-under on whether they backdated the
Mr.
envelopes?
Lally, earlier when you talked about the DNA, you said that on 9/26, one item, the testing should be complete. The
David has
other,
Johannes,
the
all of
last
us
week
right
in
now.
October. And then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 date was in reference to the DNA work that was completed on August 1st.
Poor Karen.
That was
Look
the
at her face.
second round of exhaustive testing in which their expert, Mr. Lakin, was present. That we had to delay because of his, first, his availability, and second, not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to two separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing. That has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions, every single bit of testing that's been done.
What about all the lies that you
As
said
per
when
the
you really
court's,
didn't communicate with
suggestion
them,
and
but you said you
direction,
did?
I've requested expedited
No, but we're just going to
analysis,
gloss right over
with regard
that?
to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
This is September.
So what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been tested.
Mhm.
And I want the Commonwealth to be able to report back in the
8
beginning of
items that have not been
November
tested.
the results of all of the testing that's been completed. And if it's not completed,
8 holes in the
why,
shirt? I don't think that's
and
what it
when you
was.
expect it
Was
to
it?
be completed. Why don't we have all of that by November 3rd?
That's what we're doing right now. Maybe we could. Good idea,
For
Dennis.
B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth.
No grave
Your experts
concerns.
need to talk, and you need to put something in writing.
No grave concerns. At least Karen wasn't sitting in jail.
Stand up at the microphone so I can hear you.
And
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on
Give her
a
back
disc
the damn
and on
car.
the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced.
yeah, not seeing the first trial in these hearings, you missed so much,
All
Dodger
right,
Girl.
so
This is why
the
this is so
request
good. Thank you,
D-
Kelly Reed, for suggesting that we go back and listen to Lally's lies from September 2023 and for sending me the link to this video, which I do not believe is on Trial Channel. This is from Canton Community Television, who was there like from day one, like recording all of these hearings. I will link this hearing for you below. I don't know if it's anywhere else on YouTube. This is on their website. And you guys did. I mean, we've been mass lit for years on this case, and yeah, we can do better than 2,300 likes. We got over 4,400 watching. Yeah, thank you, Boston Girl 79 Charissa. It's wild. If you guys want me to link it, I'll link it below.
Is the Office of the Medical Examiner, is that all taken care of? The original death certificate?
Oh, the death
You
certificate.
didn't raise that this
I mean,
morning,
this just
Ms.
goes
Little.
on and on and on. There's still,
Okay,
you
so
know,
request number 5.
there's still another hour left in this hearing. So I will link it below for those of you who would like to watch it again. But thank you, Kelly Reed, for sending me the link to this, because I forgot. Of course, I have a million emails and I forget where they are. They also have a lot of, they also have the board meetings with Selectman Chris Albert. That is right. Thank you, Sam's Galaxy. And everyone make sure you hit the like button, because we're here doing the Lord's work. We're here doing the Lord's work, and we're here helping also, we're helping Rosemary Scapicchio with her arguments, because Lally lies Lally is a lying liar who lies. Liar, liar, pants on fire. Anybody who's watching right now, are you sitting at an airport somewhere? Because about a half an hour ago, United Airlines, the FAA issued a ground stop for United Airlines flights, several U.S. airports, because there's some sort of tech outage. So if you're sitting in an airport somewhere waiting for your United Airlines flight, we're happy to have you and to keep you company, because that sucks. Why are there so many ground stops lately? Why are there so many days when they have to, as such, stop flights? What is going on? Is drones? What is happening? Are all of these systems getting hacked all the time? Because all this started happening after like the drones that people were seeing these drones around everywhere. I don't know. I'm not a conspiracy theorist, but if I was, Slancha Aaron, thanks for becoming a member. And Charissa gifted another membership. And Lady Zelda Kelly is here. Says, thank you so much, Ms. Melanie, for all you do. Lady Zelda, can you email me, or I'll email you, and I'll come on your show one night this week if we could do that. You want to do like a reading for me or something? Because that'd be really cool. Because I just want to say, Lady Zelda, if you guys do not follow Lady Zelda Kelly, you have been missing out on all of the readings and all of the card readings and all of this like other stuff that I don't really understand, where spirits speak. And John O'Keefe spoke one night and all these words came up on a screen and it was crazy. Maybe you could do a reading for me or something, because I do believe in the spiritual world, and as such, that kind of thing. So I'd love to come on your show. And I know we've been trying to put it together for a long time. So if you don't follow Lady Zelda Kelly, please do it, because her voice is just, there's something about your voice that I just love. It's really just makes me happy. I don't know. You have a very soothing voice. And I know we've been trying to get it together for a long time, and I would love to tell my future. Do a reading for me. I have the angel numbers book, so I look up numbers all the time, but I need some spiritual guidance, Lady Zelda. Also, Sarah Go Forth says, does anyone know who Sunny Spirit is, who keeps dogging Melanie? That is one of the Twidiots. If anybody does know who that person is, IRL, let me know. I have been hearing that they've been trashing me for as long as I've been covering this case. So if anybody knows the actual identity of this person, this Twidiot, please let me know, because I do not know. New Hampshire woman says, Bev's voice is making my eyes twitch. You're not alone. Kokomo, Indiana says, is this on the Trial Channel site? No, it is not. It is on Canton Community TV. I will link it below so you can watch it. Jackie 1111 says, thank you for a lovely month, Melanie. Oh, thank you for being here for a month. The first month is the hardest. I'm an acquired taste for a lot of people. It's kind of like sushi or beer or Dave Matthews. It's like you either love it or you hate it. And I have a lot of haters, and I'm okay with that. I'm too old to care. And I have enough drama in my life that I do not participate in the online drama. And that's why thank you, Cal. That's why we try and keep the drama out of the chat, because I just can't stand it. And then people yell at me for yelling at the chat, and then doesn't go well. But I'm an acquired taste, and those who love me, and they're here. They're the cupcakes. Mm-hmm. Oh, and Olivia Niles says, I love sushi and Dave Matthews and Melanie, of course. It's an acquired taste, but right? If you know, you know. Oh, Sweetie No said, hey, remember when she used to occasionally grant a defense motion? She even mentioned a hearing. Yes. And then we pointed out that hearing got canceled, right? Like on the day. Letter Rose by Better. I put this one up before as well. And Connie Goudreau, I did ask you if you were related to the Goudreau brothers. Silence is complicity, says Boston Girl 79, aka Charissa. Thanks for speaking up. Somebody's got to. Scott McGinnis says exhaustive testing was for the hair found on the fender. State Police Crime Lab found no DNA, so exhaustive testing was needed from Bodie Labs, in which the hair would be destroyed. That's right. And they said, if you want to come, you got to pay something like $20,000, $22,000, something like that. Right? I think that's right. And then Charissa gifted another 5 memberships because she's awesome. So if you are a new member, enjoy the new emojis. Oh, also, we have, buffs, because I am a proud alum of the University of Colorado. Go Buffs. And also some Grateful Dead and Dave Matthews symbols. We got a fire dancer and a Steely and a dancing bear. Because if you know, you know. Yeah, they did play last weekend for the 60th anniversary, Lisa Davy, in San Francisco, in Golden Gate Park. I was not there because I was here. I had a family party that I could not miss, but it is on YouTube. You can find it on YouTube under the Dead and Company channel. And by the way, I think I have more subscribers than the Dead and Company channel. Don't subscribe to them because I want to stay ahead of them. But they did play on YouTube through nugs.net, which is also an amazing live concert streamer. Nugs, we love Nugs. They played at least the opener for every night, and it's on YouTube on the Dead and Company channel, so you can check it out. It's cool. And then SiriusXM played night 3 for all on SiriusXM on the Grateful Dead channel. And also, who played with them? Billy Strings opened like one night. Sturgill Simpson. I think his name's Sturgill Simpson. Yes, John Mayer does play with Dead and Company now. Yes. And there's that. So that's awesome. Thanks again, Charissa. And Texas Prime. We coming. That's Coach Prime. We coming. Last night I went back and watched your coverage of Judge Bev's denial for the evidentiary hearing. It was awesome. Everything you said ended up being true, and Bev's justifications were awful. Oh, is that the one where I read the motion to dismiss decision? And I was trending on Twitter, even though I'm not on Twitter, because I said drop the F-bomb so many times, and I typically don't curse just because my audience appreciates it. Not that I don't in real life, but that was it. The motion to dismiss where I read the decision. Yep. It's true. I know sometimes I get it right. Sometimes I get it right, right? Thank you, Texas Prime, for your 10. Barbie says, I happen to know a lot about Lexus. I own 2. One's a GX. My GX will not allow you to back into a person. I know weather can affect that, but this is when I knew she was innocent. Thanks, Barbie. Dennis says, Melanie, I so appreciate your channel. If you still need something for tomorrow, maybe going back over some of the Lally lore based off of what happened yesterday, Myles King. Yes, we could do a whole Lally Lies series because, you know, we are here to help the people who are out there being wrongfully persecuted. Not that, I mean, Myles King could be 100% guilty. I have no idea. Apparently, on his deathbed, allegedly, the victim, Marcus or Marquis Simmons, named him as the shooter. But again, who reported that? Was it Proctor? Like, who knows? They don't wear body cam. I don't know. He could be guilty as hell. But there needs to be constitution and procedure, and we have rights, and our rights need to be respected. Aaron Spencer is another one we need to free. Aaron Spencer, if you don't know about Aaron Spencer, I'll tell you at the end about Aaron Spencer, but I have a whole playlist on Aaron Spencer, and we can only hope that the charges against Aaron Spencer will be dropped like they were against Mr. Patel today in Cobb County, Georgia. Although I was really looking forward to Ashley Merchant trying that case, but it's okay. Maybe I can get her on the show. She went on AV's show. Maybe she'll come on my show. Okay. Ideas. I got all these ideas in my head right now. They're all swirling in my head. Thank you, that girl 7177. Love you, Mel. So happy to be here. I'm so happy that you're here too. Thank you so much for being with me for 6 months. It's a long-term relationship. Chloe says, Lally gets an inherent decent guy bias because he's so boring, monotone, and has bad hair. Same as SBF. Stan Bankman-Fried. We think evil is interesting and well presented. Right. Right. Josh says, I see the Commonwealth's game. Oh, you're asking for this? We'll give it to you the day we have to speak about it in court. Right. And then you won't have a chance to go back and put that CD into your computer. I'm surprised it wasn't on VHS, to be honest with you, or the flash drive or whatever it is. And so you don't really know what's on it. You don't know if, as in Turtle Boy's case, the last hearing that we watched, Robert Cosgrove said, I've just handed the defense between 5,000 and 6,000 pages of discovery. And then, of course, when Tim Bradle got back to his office and put the thumb drive in, or CD or VHS tape or whatever it was, he found that 4,000 of those pages were blank. Another couple hundo were completely redacted. But at least Cosgrove could say in open court, oh, I just handed them 6,000 pages of discovery, but it was a lie. And that's exactly right, Josh. Exactly. You've got their number. You're on it. Venus Blue Trial Bunny says, Mel, you should travel to Lily Dale, New York, hidden gem. Oh, thank you. I've never even heard of it, but I will look it up. Thank you, Trial Bunny. BB2 says, it's your channel. You can do what you want. Those who don't like it should leave. BB2 was my first member ever on my channel. Channel just turned 2. And PB was my first member, the first one who ever signed up for memberships. And that was 22 months ago because I didn't start memberships for like a couple of months after the channel started. So Kelly Chloe Bit. So we quit. Has been here for 9 months. Can we name it the Lally, Lie, Tally, and Count? Wait, where's my resident statistician? Zoe? Wasn't Zoe keeping track of everything during whatever trial it was that we did last? I guess it was Karen Reed. Oh, Cass is here and she says you were the first subscriber. Cass was the first subscriber. There she is. That's right. Before I even had a channel. It's just a girl with a YouTube profile pic. The Lally Lie. Sammy says, I absolutely love your channel. If you ever need info on Arkansas cases, let me know. Hashtag free Aaron Spencer. Okay. Going to give you the quick rundown. Free Aaron Spencer. Thank you, Sammy, for reminding me. If you think Norfolk County is bad, you need to check out Lonoke County, Arkansas. Here's what happened. Here's the story of Aaron Spencer and Aaron Spencer's family. Okay, let me make sure I'm getting the dates right. In July of 2024. Yeah, July of 2024. Aaron Spencer's daughter, who was 13 years old, told someone that she trusted that she had been SA'd several times, raped by a 67-year-old man unknown to her parents. And she disclosed in July of 2024, but it actually happened back in June of 2024. When this person told Aaron Spencer and his wife, the girl's mom, what had happened, they did what any parents would do, and they went to the police. They reported it to the sheriff or someone of Lonoke County. I'm just summarizing right now. The man, his name is Michael Fosler, Fosler, which we have come to find out was the chief of police in Hamlet, Indiana in like the 90s and had relocated himself to Arkansas for, I don't know what reasons you decide. He's pretty much scrubbed off the internet. Michael Fosler was the chief of police in Hamlet, Indiana in the 90s. And now he's a rapist in Lonoke County, Arkansas. And he did it to this 13-year-old girl. They go to the police. Eventually, Michael Fosler is arrested. It is done very quietly and very secretly. And then there's a judge in Lonoke County. Her name is Barbara Elmore. Barbara Elmore, even though Michael Fosler is charged with 43 felonies against this girl, 43 felonies, including not just the assault charges and the rape charges and there's something like 40 things on his phone that are CSAM. 43 felonies. Judge Barbara Elmore releases him on $5,000 bond and gives him a piece of paper called a restraining order, says you can't go near this girl and her family. And he gets out. And everything is sealed. And nobody's allowed to see what the charges are, nothing. And that is sometime, I believe, in September. In October, around October 8th, I want to say, in the middle of the night, the family is trying to heal. They've got their daughter in therapy. They're trying to do everything they can because they think the judge, that this guy's going to stay away. In the middle of the night, they hear her dog barking, and her dog starts barking, the daughter's dog, and Aaron Spencer, the wife, says, maybe she's sick. Can you go in and check? And he goes in, and she's not in her bed. She's not in her bed, but her bed is stuffed with a stuffed animal to make it look like she's in her bed. They freak out. They call 911. They say that we have a restraining order against this guy. He may have her. Can you go to his house? And then he, like any father would do, doesn't know what to do. He's freaking out. He grabs his keys. He gets in his truck and he goes, or whatever his vehicle is, and he goes out to look, see if he can find her. And he just so happens to find this guy driving his truck with his daughter in the passenger seat. Just happens upon them. A chase happens. He pulls a Yui. He chases after that truck with his daughter in the passenger seat. He's freaking out. And then I guess he bumps the car somehow. The car goes into a ditch. The guy's car goes into a ditch. There's a struggle ensues. He is able to get a hold of his daughter, but the guy's grabbing his daughter. He's trying to get his daughter out of the car. He gets his daughter out of the car. Michael Foster goes to grab something out of his pocket. And Aaron Spencer pumps him full of lead, leaves him in the ditch, calls 911 and says, by the way, something like this. I'm summarizing. I'm not a witness to this case. The daughter was 13. By the way, the guy I called you about before, he's lying on the side of the road. Here's his location. You might want to send an ambulance. He dies. Foster dies. The father, Aaron Spencer, is now they wanted to charge him with first-degree murder, but instead they charge him with second-degree murder. The arraignment of Aaron Spencer is closed to the public. 10 days after he's arraigned, Judge Barbara Elmore, yes, the same judge who let Michael Foster back on the streets, slaps an unconstitutional gag order on the case so nobody can talk about it, not Aaron Spencer, not his family, not the attorneys, nobody. It went all the way to the Arkansas Supreme Court. It was overturned as unconstitutional. The gag order has finally been lifted. We started talking about the case. The case has just been adjourned. There was supposed to be a pretrial hearing this week, and then the trial was supposed to start in September. It has been adjourned to December for the pretrial, January for the trial. It's in Lonoke County, Arkansas. And we need to free Aaron Spencer. And Arkansas is a stand your ground state. Thank you, green-eyed Southern girl. And I don't think she would have came home alive if her father didn't go out looking for her. He saved her life. So if you don't know anything about it, there it is in a nutshell. And I've got a whole playlist on it. And we're not going to shut up until we free Aaron Spencer too. And when I put up his give, send, go, I think there was like $13,000 in it. You guys were so generous. And then other people started picking that up, and I don't know what it's at now, but last time I checked, it was like, $34,000 or something. The trial was pushed back, I think, because they probably have more discovery to do and more motions to make, and motions in limine, because the gag order was just lifted. So the case was stayed during the time that it was up in the Arkansas Supreme Court. And so there was a long period of time where nothing could happen. Chloe says, FAA is a federal agency. Those lost lots of staff. Talking about the United ground stop. So many side conversations. Texas Prime says a Lally series would be great, and I bet AJ and Yannetti would find it helpful when drafting up that 1983 filing. Lally has definitely shown a pattern. Oh, yes, he does. Yes, he has. It writes itself, doesn't it? Tripoli Bob says, will the Commonwealth have to unimpound the sidebars from the Karen Reed trial, or can they keep them sealed forever? That is a great question. They should not have to. They're part of the court record. And so they cannot be sealed forever. I don't know if the Massachusetts rules require them to be sealed for a certain period of time. I do not know if it requires a motion be made to unseal them. And I'm conflating everything in my head right now. Has anyone made a motion to unseal them? I think so many motions, so little time. They will not be sealed forever. They're part of the court record, and they got to eventually be unsealed. I just don't know when. Thank you for your 10, Tripoli Bob. Sammy says, sealing court docs, even search warrants, they claim due to small populations and don't want to bias a jury. Yeah, in Arkansas. You're correct. The Arkansas Supreme Court completely disagreed. They said you can do a full-throated voir dire during jury selection and weed out the people who you think are biased. Is it a full moon? That makes sense. Those sidebars need to go to Unimpound Town, says Melanie Little's left swipe in Norfolk County. Preach, girl, preach. Do you guys want to hear Howie Carr's column from today if you haven't seen it? Thank you, Marie, for your Venmo. Says, thanks for what you do. I still have to watch the first stream you did today. That was a short one. That one was like under an hour. Thank you. Thank you, Marie. You're so awesome. And I love you so much. And Jonas, this was from earlier today. I grew up in New York, worked in West Hampton and Montauk. And rest in peace, Martha Nolan O'Slatera. It really makes me sad. Yeah. Very sad case. You would like to hear Howie Carr? Okay. I'm here for you. I'm here for you. I need a sip though, so just give me 2 seconds. And I also got to turn up the fan. So I'll put Howie Carr up. There's also another great article here on defense attorneys join the civil case. Lawyer blast complete failure by DA. That is Rosemary Scapiccio. But let me take that down. Let me just put this up and turn on the fan. Give me 2 shakes of a lamb's tail. BRB. KBD almost spit her coffee out on the title. About the title, which is Porky Proctor's Humiliation Served Up. This is Howie Carr's column from today. So I'm not the one doing the fat shaming. Blame Howie Carr. Hang on, let me see if I can why can't I full screen this dopey thing? Hang on. All right. Oh my God, that's very small font. Porky Proctor's humiliation served up. Yeah, people were pointing out, I think Turtle Boy did point out the the tan lines for the back of the cap. And he did try and ask him some questions yesterday, and his attorney turned around and called Aiden Mr. Media. Okay, Mr. Media, what do you want? That was funny. God bless Howie Carr. Howie watches my show too, so shout out, Howie. In fact, I think it's my voice in his opener saying something about a cup of Joe and Howie Carr. Did you guys hear that? I sent it to someone. I'm like, does that sound like my voice that Howie Carr is using in his opener? And I think it's me. I know my voice. Okay. Porky Proctor's humiliation served up. The clock is ticking down until Karen Reed files a massive multi-million-dollar Section 1983 federal civil rights case against the Massachusetts State Police et al. In a few weeks. 3, 2, 1. That's what all her subpoenas last week were about. The Karen Reed team is laying the groundwork for the big daddy of all local lawsuits. Karen Reed and her attorney, Alan Jackson, who just signed on to the latest twist in this legal take no prisoners legal struggle, aren't sweating the sad wrongful death suit brought in Plymouth County by John O'Keefe's family. If 2 juries a year apart agreed that Karen Reed didn't hit O'Keefe with her SUV, how are the scheming O'Keefes going to cut themselves a nice big piece of cake, at least against Reed? Maybe their ambulance chasers can prevail against the dive bars of Canton, but Karen should skate. Howie, if he wasn't hit by a car, the bars can't be held responsible either. I'm just saying. And really, ambulance chasers would take offense to that because, I'm a plaintiff's lawyer too, and I did sue the Catholic Church. So there are good ones. We do good as well. And we help people rebuild their lives. The pending federal lawsuit against the lynch mob is just the latest indication that since the not guilty verdict in June, in Norfolk County, the hunters have become the hunted. It's like the old Marvelettes song. Sometimes the hunter gets captured by the game. Right, DA Meatball Marcy? Yesterday, it was the disgraced plus-sized ex-state trooper Michael Proctor back in that same Dedham courtroom where he was so badly humiliated last year by having to read his own obscene texts. This time, the crack sleuth had to appear in connection with another murder case he totally botched. Since his firing by the state police, Proctor has packed on at least 50 pounds. He looks like he's been sucking on a helium gun. Step away from the helium tank, sir. There's some people that talk like that too. That was a joke. My family, step away from the helium tank. People that talk like this. He morosely waddled out of the courthouse yesterday. Proctor was confronted by his nemesis, Aiden Carney, aka Turtle Boy. How's the diet going? Turtle Boy asked him. No response, not even a burp. Have you found gainful employment since you've been fired by the state police? Turtle Boy followed up. No answer. Joining Proctor in court was Meatball Morrissey's clownish prosecutor, Adam Lally. They're both accused of slow-walking evidence in the Myles King murder case in Milton. Ironically enough, a day earlier on Monday, Proctor was in front of the Civil Service Commission. Don't laugh, but he's trying to get his job back using the tired, quote, disparate treatment argument that he's being treated differently than all the other crooked state troopers who've gotten lugged recently. Imagine that. How does he think Karen Reed felt about her disparate treatment? Out of 7 million people in Massachusetts who didn't murder John O'Keefe, she was selected by the corrupt cops in Norfolk County to be framed for his murder. Oh my God, that is so good. I got to read it again. Just that one sentence. Out of 7 million people in Massachusetts who didn't murder John O'Keefe, she was selected by the corrupt cops in Norfolk County to be framed for his murder. Proctor is whining that he needs the disciplinary reports of all the other state cops who are jammed up. He claims the state police aren't turning the evidence over to him in a timely fashion. You know, sort of like Proctor is accused of not turning over the evidence in the murder case where the guy who's probably very guilty had to sit in jail for more than 3 years. So it was okay for Proctor to not give a bleep about turning over evidence quickly. But now that he's jammed up, Porky Proctor is screaming bloody murder because the MSP brass are stalling, handing the evidence he claims he needs. What goes around comes around. Karma, Proctor, karma. It would take a heart of stone not to laugh. I wonder if Proctor wants to see the records of how other state troopers were treated who were busted cold soliciting gifts to their wives after arresting an innocent woman to make sure the connected people would walk. As badly as many state troopers have behaved in recent years, I'd bet not a single other one is on the record as soliciting such bribes or gifts, especially in a murder case. A murder case where an innocent woman was framed. How about all the other state troopers who are on record fantasizing about their victims killing themselves? How have they been treated in their disciplinary hearings? Let me guess. Proctor's again the only one who's ever been busted for wishing his innocent victim killed herself. How about all the other state troopers treated who got caught getting drunk in their cruisers with local cops? Don't tell me there aren't any. Next up in Karen Reed 3.0 is a hearing a week from today to unseal all of Meatball Morrissey's secret texts in the Turtle Boy frame-up. Turtle Boy already has those salacious texts, as he describes them, in his possession. Once Turtle Boy gets the okay from the judge to release them, there will be yet another torrent of comic gold about the corrupt Keystone cops in Norfolk County. It'll be a worse day for Meatball than yesterday was for Porky Proctor. Meanwhile, Karen Reed's attorneys are putting the finishing touches on that Section 1983 civil rights case. It'll be in federal court, so Karen Reed won't have to worry about Judge Beverly Cannoni. After Karen's second acquittal in Cannoni's kangaroo court, the bloated judge... Excuse me for a second. The bloated judge got herself transferred to Plymouth County, where the O'Keefe's lawsuit will be heard. It's almost like Auntie Bev is stalking Karen Reed. Somebody yesterday, I'm just going to break for this for a second to say, somebody yesterday started calling Judge Krupp Uncle Bev. I'll allow it. Uncle Bev. Weren't 2 criminal trials enough for Bev, making Reed go through double jeopardy after her acquittal in last year's trial, after sustaining 49 consecutive objections during Alan Jackson's examination of one of his witnesses? When it came to Karen Reed's evidence, Auntie Bev somehow decided that the word exculpatory in fact meant excluded. Well done. Right now, the judge in the O'Keefe civil lawsuit is Daniel O'Shea. He seems in good enough health, but what if he's suddenly hit by a bus? Does Auntie Bev get to step in and reconvene her necktie party a few miles south? Stay strong, Judge O'Shea. As for you, Porky Proctor, it's just good to know that you're not letting your legal travails and the end of your squalid career as a crooked cop affect your appetite in the slightest. How's that diet going? Bum. Somebody said it's a little over the top, but I suppose it's warranted. Well, Howie Carr, if you have never read Howie Carr before, every column is like this. Every column, every day is comedy gold. And they're not all about the Karen Reed case, but when they are, we're here for it. Aren't we? Thank you, Aunt BB, for another 10. She says, I believe the dog was a rescue. He certainly paid it forward. He returned the love it by rescuing her. Yes. Oh, you're talking about Aaron Spencer's daughter. For a second, I thought we were talking about Corey or Chloe. Chloe or Cora. Chloe or Cora, the only dog ever in witness protection, or maybe 6 feet under. But yes, Aaron Spencer's dog may have been a rescue. He was certainly paid it forward. He returned the love by rescuing her. I know. He should not be on trial for a murder. Should not be. Sammy says, I appreciate you not even attempting to pronounce my last name. Hold on. Biswanger. LOL, it's not easy. Biswanger. Sometimes it's just faster for me to just read first names, but Sammy Biswanger. Did I say it right? Thank you. Thank you very much. Please look into the Derek Todd case. You were tagged on TikTok, USMC 6553. I rarely check TikTok, but I did check it yesterday and I did see that and I will. But is he in jail already, Derek Todd? I remember quickly looking into it. I didn't have a lot of time. And I will. Is the trial coming up? Is he already in jail? I have a lot of questions about that. It was not something that I could do quickly, but I did see it. So thank you for that, for reminding me. eBay Warhol, Tracy Fagan says, I was watching a trial today with the GBI that used a dryer closet where you hang up the clothes to dry, then to dry them butcher paper to catch evidence on the bottom. Oh, so that's the way they do it in Georgia. Is that Georgia? Yeah, that's the way they do it. They don't really do anything by the book in Norfolk County because they have no procedures or policies or protocol. Nobody seems to know. If they do have them, they don't seem to know what they are. Welcher's emotional support laptop knew Derek Todd in college. Huh. And Kat Randall is here and gifted a membership. Thank you, Kat Randall. Thank you, Bob Cromwell, for your super sticker. And Pierre says, Proctor, let's talk about all the details of what other officers did and why have they not been fired? You are vile, but you are being scapegoated too. Spill. Thanks, Pierre, for your 10. For always fighting for justice with me. And Josh says, so according to Massachusetts, Howie Carr is a journalist. Aidan Carney is only a blogger. What is the difference? Well, listen, the rules to get a media pass in Massachusetts, I'll tell you what they are, because it took Brian of LTL YouTube channel 2 years to get his media pass. And Mike Crawford of the Young Jerks, who has actually won awards for his journalism, can't get one. Aidan Carney does have a media pass. And I think journalist, calling him a blogger, I think is a dig. And so I think that's what they're doing. They're digging him every single time. And Aidan Carney has done more single-handedly to investigate the murder of John O'Keefe than the Massachusetts State Police and the Canton PD and the Norfolk County District Attorney's Office combined. So there's that. Yeah, so you have to, it's like ridiculous. It is so ridiculous to get a media pass. Let me see where it doesn't have the actual rule. There's like a 2-page application that you have to fill out. here's what you have to you show to get one. Okay, might as well look at it because we're here. If you would like to obtain a media pass in Massachusetts, here are the media credentials application instructions and requirements. The non-transferable media identification card provides an exception to the court's policy regarding electronic devices. A valid media identification card will entitle an individual to bring to a courtroom a laptop with a silent keyboard and/or a cell phone that must be off or in silent mode while in courtroom. All media identification cards will be subject to the provisions of the attached local rule 83.3 that prohibits photographing, recording, and broadcasting. Applications for media credentials should be submitted to the office of the clerk of the court at Uncle Joe's house in Boston. The application is to be printed or typed, completed by each applicant, and certified by an editor or a news director. Okay? So I guess if you're self-employed as your own editor and your own news director, you don't qualify. Media identification cards will be valid for 3 years. They will be issued to full-time members of the media who have a need for an identification card in order to fulfill their various assignments. Media identification cards will not be granted to individuals who are employed in the business, advertising, or circulation departments. First-time and renewal applicants must include the following items with their application. 1, a cover letter from the applicant's editor or news director requesting credentials for the individual. It's a little prejudicial, isn't it, to people who are self-employed? If numerous applications are being filed, one letter with all the applicants' names will suffice. For independently employed applicants, reference letters from at least 2 agencies that recently have hired them on a freelance basis. The company name box on the application should indicate self-employed. So if I'm here on YouTube reading you the news and reporting on the news and reporting on trials every day, but I've never been hired on a freelance basis by anybody, any agencies, I can't submit that. I don't have reference letters to submit. And that's it. That's all. That's the only things that they'll accept. I don't know. Crazy. Freelance journals have been around for many, many, many years. Yeah, but if you haven't been hired on a freelance basis by an agency, at least 2, and they can't supply you with reference letters, then you don't qualify. So there's that. Another more hoops you got to jump through. Thanks, Mimi, for becoming a new member. Thanks, Mimi. And my friends, thoughts, questions, comments, concerns before we wrap for the evening. If we buy memberships, are we technically employing you? We'll write you letters. Thank you, Kylie. Thank you. Mitchell says I have 126,000 references. 126,000 of them. Thanks, you guys. Someone should sue, says the one and only DRE. That sounds like a First Amendment violation. Yeah, these rules are antiquated. They're antiquated. That's the way they do it in Massachusetts, folks. And they want to hide everything from you. You know how it is. They want to hide everything from you. Massachusetts is ass backwards, and they're mass lighting. They're absolutely mass lighting. Don't you think? I don't know. I don't know how Grant Ellis got a press pass. I don't know. Maybe his mother wrote him a reference letter. I have no idea. All right, you guys, let's wrap this one. We've been on here for 3 hours and 15 minutes, and we did the other one for like 45 minutes. So that's like 4 hours today. I think that's a good run. We had a good run today, didn't we? You're going to want to make sure that you hit the subscribe button because it's free. And you're going to want to make sure that you hit the notification bell so that you'll know when I go live, because I'll plan some for you for tomorrow. I just don't know what it's going to be or what time it's going to be yet. So unless you have your notification set, you're not going to get them. But please, thank you, Ashley. This was great. So we pivoted. I have to go back now and change the title because I had a feeling that what I wanted to cover, I would pivot to something else. And then Kelly Reed gave me that really good idea. And then we did that. And I still had like 2 other articles to read to you. But I think what we'll do is we'll cover the civil case on another day when we talk about 1983 actions. And we'll talk about the potential causes of actions and all of that things. All those things and stuff. Thanks, Rena, for becoming a new member. And thank you to the moderators who are amazing. And Karen Goldberg says, New York City in the AM. First time leaving our kids in 13 years. Oh my gosh, you are due a vacation, girl. XLE here. Proctor's lawyers said he's learning communications. Is he going to be a dispatcher? Oh, I don't know. I don't know. He did say that to Turtle Boy, right? Have a fun trip. Have a fun trip. Stay safe. Stay safe, Karen, and have a wonderful trip. And not leaving your kids in 13 years. You gotta nurture your relationship. All parents need time away from their kids. Don't you agree? So many things that I want to talk about, like the end of the Sex and the City. I just saw a really cool video on I think Architectural Digest posted it on YouTube. It's a walkthrough of Carrie's Gramercy Park house and the set, and it's really cool. So if you guys are into that and you're into set decor and stuff like that, check it out. Architectural Digest. I'm going to post the link to that entire hearing below this video so you can go back and watch it at your leisure. And, you know, trigger warning, it's going to give you PTSD because we all have it. We were there. Thank you, moderators. Love you all. Without you, I wouldn't be able to do what I do. Thank you to each and every one of you who chose to spend part of your evening with me tonight. I am so, so grateful for each and every one of you. I know that you have many places to watch your YouTube coverage, and I'm so honored that you choose to spend it with me. Stay cool, stay kind, stay classy. I'm going to see you real soon, everybody. Smash the like on your way out. I promise you, the MSP won't get your DNA. And even if they did, they wouldn't know what to do with it. Peace.